Welcome to Supreme Court Opinions. In this episode, you'll hear the court's opinion in Allen v. Milligan. In this case, the court considered this issue. Does Alabama's 2021 redistricting plan for its 7 U.S. House seats violate Section 2 of the Voting Rights Act? The case was decided on June 8, 2023. The Supreme Court held that the district court correctly applied binding Supreme Court precedent to conclude that Alabama's redistricting map likely violates Section 2 of the Voting Rights Act. Chief Justice John Roberts authored the majority opinion of the court. The court's decision in Thornburg v. Gingles sets out a three-part framework for evaluating claims brought under Section 2 of the Voting Rights Act. First, the plaintiffs must prove that the minority group is sufficiently large and geographically compact to constitute a majority in a reasonably configured district, measured by criteria such as contiguity and compactness. Second, the plaintiffs must show that the minority group is politically cohesive. Third, the plaintiffs must show that under the totality of the circumstances, the political process is not equally open to minority voters. The majority applied that three-part framework to the facts in the record, and agreed with the district court that the plaintiffs were likely to succeed on their challenge. The plaintiffs submitted maps demonstrating the traditional districting criteria, and the district court found no serious dispute that black voters are politically cohesive, or that the challenged district's white majority consistently defeated black voters' preferred candidates. Justice Brett Kavanaugh joined the majority opinion except for a discussion of the difference between race consciousness and race predominance. He concurred separately to emphasize and clarify 4 additional points. Justice Clarence Thomas authored a dissenting opinion, in which Justice Neil Gorsuch joined in full, and Justices Amy Coney Barrett and Samuel Alito joined in part. Justice Thomas argued that Section 2 of the VRA does not require Alabama to redraw its congressional districts so that black voters can control a number of seats proportional to black voters in its population. Justice Alito authored a dissenting opinion in which Justice Gorsuch joined, arguing that the majority's understanding of Gingles, specifically its understanding of the phrase reasonably configured within the context of the first precondition, is flawed, and that a correct understanding would lead to a different result in this case. The opinion is presented here in its entirety, but with citations omitted. If you appreciate this episode, please subscribe. Thank you. Chief Justice Roberts delivered the opinion of the court, except as to Part 3B1. In January 22, a 3-judge district court sitting in Alabama preliminarily enjoined the state from using the districting plan it had recently adopted for the 2022 congressional elections, finding that the plan likely violated Section 2 of the Voting Rights Act. This court stayed the district court's order pending further review. After conducting that review, we now affirm. Shortly after the Civil War, Congress passed, and the states ratified the 15th Amendment, providing that the right of citizens of the United States to vote shall not be denied or abridged, on account of race, color, or previous condition of servitude. In the century that followed, however, the amendment proved little more than a parchment promise. Jim Crow laws like literacy tests, poll taxes, and good morals requirements abounded, rendering the right to vote illusory for blacks. Congress stood up to little of it. The first century of congressional enforcement of the 15th Amendment can only be regarded as a failure. That changed in 1965. Spurred by the Civil Rights Movement, Congress enacted and President Johnson signed into law the Voting Rights Act. The act created stringent new remedies for voting discrimination, attempting to forever banish the blight of racial discrimination in voting. By 1981, in only 16 years' time, many considered the VRA the most successful civil rights statute in the history of the nation. These cases concern Section 2 of that act. In its original form, Section 2 closely tracked the language of the 15th Amendment and, as a result, had little independent force. Our leading case on Section 2 at the time was City of Mobile v. Bolden, which involved a claim by black voters that the city's at-large election system effectively excluded them from participating in the election of city commissioners. The commission had 3 seats. Black voters comprised 1/3 of the city's population, but no black preferred candidate had ever won election. The court ruled against the plaintiffs. The 15th Amendment, and thus Section 2, prohibits states from acting with a racially discriminatory motivation or an invidious purpose to discriminate. But it does not prohibit laws that are discriminatory only in effect. The mobile plaintiffs could register and vote without hindrance. Their freedom to vote had not been denied or abridged by anyone. The fact that they happened to lose frequently was beside the point. Nothing the city had done purposefully excluded them from participating in the election process. Almost immediately after it was decided, Mobile produced an avalanche of criticism, both in the media and within the civil rights community. The New York Times wrote that the decision represented the biggest step backwards in civil rights to come from the Nixon court, and the Washington Post described Mobile as a major defeat for blacks and other minorities fighting electoral schemes that exclude them from office. By focusing on discriminatory intent and ignoring disparate effect, critics argued, the court had abrogated the standard used by the courts to determine whether racial discrimination existed, whether such discrimination existed. But Mobile had its defenders too. In their view, abandoning the intent test in favor of an effects test would inevitably require a focus on proportionality. Wherever a minority group won fewer seats in the legislature than its share of the population, the charge could be made that the state law had a discriminatory effect. That, after all, was the type of claim brought in Mobile. But mandating racial proportionality in elections was regarded by many as intolerable. Doing so, wrote Senator Orrin Hatch in the Washington Star, would be strongly resented by the American public. The Wall Street Journal offered similar criticism. An effects test would generate more, not less, racial and ethnic polarization. This sharp debate arrived at Congress's doorstep in 1981. The question whether to broaden Section 2 or keep it as is, said Hatch, by then chairman of the Senate subcommittee before which Section 2 would be debated, involved one of the most substantial constitutional issues ever to come before this body. Proceedings in Congress mirrored the disagreement that had developed around the country. In April 1981, Congressman Peter W. Rodino, Jr., longtime chairman of the House Judiciary Committee, introduced a bill to amend the VRA, proposing that the words "to deny" or "abridge" in Section 2 be replaced with the phrase "in a manner which results in a denial or abridgment." This was the effects test that Mobile's detractors sought. But those wary of proportionality were not far behind. Senator Hatch argued that the effects test was intelligible only to the extent that it approximated a standard of proportional representation by race. The Attorney General had the same concern. The effects test would be triggered whenever election results did not mirror the population mix of a particular community, he wrote, producing essentially a quota system for electoral politics. The impasse was not resolved until late April 1982, when Senator Bob Dole proposed a compromise. Section 2 would include the effects test that many desired, but also a robust disclaimer against proportionality. Seeking to navigate any tension between the two, the Dole Amendment borrowed language from a 14th Amendment case of ours, White v. Register, which many in Congress believed would allow courts to consider effects but avoid proportionality. The standard for liability in voting cases, White explained, was whether the political processes leading to nomination and election were not equally open to participation by the group in question, in that its members had less opportunity than did other residents in the district to participate in the political processes and to elect legislators of their choice. The Dole Compromise won bipartisan support and, on June 18, the Senate passed the 1982 amendments by an overwhelming margin, 85-8. 11 days later, President Reagan signed the act into law. The amended Section 2 reads as follows. A. No voting qualification or prerequisite to voting or standard, practice, or procedure shall be imposed or applied by any state or political subdivision and where a manner which results in a denial or abridgment of the right of any citizen of the United States to vote on account of race or color as provided in subsection B. B. A violation of subsection A is established if, based on the totality of circumstances, it is shown that the political processes leading to nomination or election in the state or political subdivision are not equally open to participation by members of a class of citizens, in that its members have less opportunity than other members of the electorate to participate in the political process and to elect representatives of their choice. The extent to which members of a protected class have been elected to office in the state or political subdivision is one circumstance which may be considered, provided that nothing in this section establishes a right to have members of a protected class elected in numbers equal to their proportion in the population. For the first 115 years following Reconstruction, the state of Alabama elected no black representatives to Congress. In 1992, several plaintiffs sued the state, alleging that it had been impermissibly diluting the votes of black Alabamians in violation of Section 2. The lawsuit produced a majority black district in Alabama for the first time in decades, and that fall, Birmingham lawyer Earl Hillard became the first black representative from Alabama since 1877. Alabama's congressional map has remained remarkably similar after Wesh. The map contains 7 congressional districts, each with a single representative. District 1 encompasses the Gulf Coast region in the southwest. District 2, known as the Wiregrass region, occupies the southeast. District 3 covers the eastern central part of the state. Districts 4 and 5 stretch widthwise across the north, with the latter layered atop the former. District 6 is right in the state's middle, and District 7 spans the central west. In 2020, the decennial census revealed that Alabama's population had grown by 5.1%. A group of plaintiffs led by Alabama legislator Bobby Singleton sued the state, arguing that the existing congressional map was malapportioned and racially gerrymandered in violation of the Equal Protection Clause. While litigation was proceeding, the Alabama Legislature's Committee on Reapportionment began creating a new districting map. Although the prior decade's population growth did not change the number of seats that Alabama would receive in the House, the growth had been unevenly distributed across the state, and the existing map was thus out of date. To solve the problem, the state turned to experienced mapmaker Randy Heineman, who had created several districting maps that Alabama used over the past 30 years. The starting point for Heinemann was the then-existing 2011 congressional map, itself a product of the 2001 map that Heinemann had also created. Heinemann worked to adjust the 2011 map in accordance with the redistricting guidelines set by the legislature's Reapportionment Committee. Those guidelines prioritized population equality, contiguity, compactness, and avoiding dilution of minority voting strength. They also encouraged, as a secondary matter, avoiding incumbent pairings, respecting communities of interest, minimizing the number of counties in each district, and preserving cores of existing districts. The resulting map Heinemann drew largely resembled the 2011 map, again producing only one district in which black voters constituted a majority of the voting age population. The Alabama legislature enacted Heinemann's map under the name HB 1. Governor Ivey signed HB 1 into law on November 4, 2021. Three groups of plaintiffs brought suit seeking to stop Alabama's Secretary of State from conducting congressional elections under HB 1. The first group was led by Dr. Marcus Castor, a resident of Washington County, who challenged HB 1 as invalid under Section 2. The second group, led by Montgomery County resident Evan Milligan, brought claims under Section 2 and the Equal Protection Clause of the 14th Amendment. Finally, the Singleton plaintiffs, who had previously sued to enjoin Alabama's 2011 congressional map, amended their complaint to challenge HB 1 as an impermissible racial gerrymander under the Equal Protection Clause. A three-judge district court was convened, comprised of Circuit Judge Marcus and District Judges Monasco and Moorer. The Singleton and Milligan actions were consolidated before the three-judge court for purposes of preliminary injunction proceedings, while Castor proceeded before Judge Monasco on a parallel track. A preliminary injunction hearing began on January 4, 2022, and concluded on January 12. In that time, the three-judge district court received live testimony from 17 witnesses, reviewed more than 1,000 pages of briefing and upwards of 350 exhibits, and considered arguments from the 43 different lawyers who had appeared in the litigation. After reviewing that extensive record, the court concluded in a 227-page opinion that the question whether HB 1 likely violated Section 2 was not a close one. It did? The court thus preliminarily enjoined Alabama from using HB 1 in forthcoming elections. 4 days later, on January 28, Alabama moved in this court for a stay of the district court's injunction. This court granted a stay and scheduled the cases for argument, noting probable jurisdiction in Milligan, and granting certiorari before judgment in Castor. The district court found that plaintiffs demonstrated a reasonable likelihood of success on their claim that HB 1 violates Section 2. We affirm that determination. For the past 40 years, we have evaluated claims brought under Section 2, using the three-part framework developed in our decision Thornburg v. Gingles. Gingles concerned a challenge to North Carolina's multi-member districting scheme, which allegedly diluted the vote of its black citizens. The case presented the first opportunity since the 1982 amendments to address how the new Section 2 would operate. Gingles began by describing what Section 2 guards against. The essence of a Section 2 claim, the court explained, is that a certain electoral law, practice, or structure interacts with social and historical conditions to cause an inequality in the opportunities enjoyed by black and white voters. That occurs where an electoral structure operates to minimize or cancel out minority voters' ability to elect their preferred candidates. Such a risk is greatest where minority and majority voters consistently prefer different candidates, and where minority voters are submerged in a majority voting population that regularly defeats their choices. To succeed in proving a Section 2 violation under Gingles, plaintiffs must satisfy three preconditions. First, the minority group must be sufficiently large and geographically compact to constitute a majority in a reasonably configured district. A district will be reasonably configured, our cases explain, if it comports with traditional districting criteria, such as being contiguous and reasonably compact. Second, the minority group must be able to show that it is politically cohesive. And third, the minority must be able to demonstrate that the white majority votes sufficiently as a bloc to enable it to defeat the minority's preferred candidate. Finally, a plaintiff who demonstrates the three preconditions must also show, under the totality of circumstances, that the political process is not equally open to minority voters. Each Gingles precondition serves a different purpose. The first, focused on geographical compactness and numerosity, is needed to establish that the minority has the potential to elect a representative of its own choice in some single-member district. The second, concerning the political cohesiveness of the minority group, shows that a representative of its choice would in fact be elected. The third precondition, focused on racially polarized voting, establishes that the challenged districting thwarts a distinctive minority vote, at least plausibly on account of race. And finally, the totality of circumstances inquiry recognizes that application of the Gingles factors is peculiarly dependent upon the facts of each case. Before courts can find a violation of Section 2, Therefore, they must conduct an intensely local appraisal of the electoral mechanism at issue, as well as a searching practical evaluation of the past and present reality. Gingles has governed our Voting Rights Act jurisprudence since it was decided 37 years ago. Congress has never disturbed our understanding of Section 2 as Gingles construed it, and we have applied Gingles in one Section 2 case after another, to different kinds of electoral systems and to different jurisdictions in states all over the country. As noted, the district court concluded that plaintiff's Section 2 claim was likely to succeed under Gingles. Based on our review of the record, we agree. With respect to the first Gingles precondition, the district court correctly found that black voters could constitute a majority in a second district that was reasonably configured. The plaintiffs adduced 11 illustrative maps, that is, example districting maps that Alabama could enact, each of which contained 2 majority black districts that comported with traditional districting criteria. With respect to compactness, for example, the district court explained that the maps submitted by one of plaintiffs' experts, Dr. Moon Duchin, performed generally better on average than did HB1. A map offered by another of plaintiffs' experts, Bill Cooper, produced districts roughly as compact as the existing plan, and none of plaintiffs' maps contained any tentacles, appendages, bizarre shapes, or any other obvious irregularities that would make it difficult to find them sufficiently compact. Plaintiffs' maps also satisfied other traditional districting criteria. They contained equal populations, were contiguous, and respected existing political subdivisions, such as counties, cities, and towns. Indeed, some of plaintiffs' proposed maps split the same number of county lines as, or even fewer county lines than, the state's map. We agree with the district court, therefore, that plaintiffs' illustrative maps strongly suggested that black voters in Alabama could constitute a majority in a second, reasonably configured, district. The state nevertheless argues that plaintiffs' maps were not reasonably configured because they failed to keep together a traditional community of interest within Alabama. A community of interest, according to Alabama's districting guidelines, is an area with recognized similarities of interests, including but not limited to ethnic, racial, economic, tribal, social, geographic, or historical identities. Alabama argues that the Gulf Coast region in the southwest of the state is such a community of interest, and that plaintiffs' maps erred by separating it into 2 different districts. We do not find the state's argument persuasive. Only 2 witnesses testified that the Gulf Coast was a community of interest. The testimony provided by one of those witnesses was partial, selectively informed, and poorly supported. The other witness, meanwhile, justified keeping the Gulf Coast together simply to preserve political advantages. You start splitting counties, he testified, and that county loses its influence. That's why I don't want Mobile County to be split. The district court understandably found this testimony insufficient to sustain Alabama's overdrawn argument that there can be no legitimate reason to split the Gulf Coast region. Even if the Gulf Coast did constitute a community of interest, moreover, the district court found that plaintiffs' maps would still be reasonably configured because they joined together a different community of interest called the Black Belt. Named for its fertile soil, the Black Belt contains a high proportion of black voters, who share a rural geography, concentrated poverty, unequal access to government services, lack of adequate health care, and a lineal connection to the many enslaved people brought there to work in the antebellum period. The district court concluded, correctly under our precedent, that it did not have to conduct a beauty contest between plaintiffs' maps and the state's. There would be a split community of interest in both. The state also makes a related argument based on core retention, a term that refers to the proportion of districts that remain when a state transitions from one districting plan to another. Here, by largely mirroring Alabama's 2011 districting plan, HB1 performs well on the core retention metric. Plaintiffs' illustrative plans, by contrast, naturally fare worse because they change where the 2011 district lines were drawn. But this court has never held that a state's adherence to a previously used districting plan can defeat a Section 2 claim. If that were the rule, a state could immunize from challenge a new racially discriminatory redistricting plan simply by claiming that it resembled an old racially discriminatory plan. That is not the law. Section 2 does not permit a state to provide some voters less opportunity to participate in the political process, just because the state has done it before. As to the second and third Gingles preconditions, the district court determined that there was no serious dispute that black voters are politically cohesive, nor that the challenged district's white majority votes sufficiently as a bloc to usually defeat black voters' preferred candidate. The court noted that, on average, black voters supported their candidates of choice with 92.3% of the vote, while white voters supported black preferred candidates with 15.4% of the vote. Plaintiffs' experts described the evidence of racially polarized voting in Alabama as intense, very strong, and very clear. Even Alabama's expert conceded that the candidates preferred by white voters in the areas that he looked at regularly defeat the candidates preferred by black voters. Finally, the district court concluded that plaintiffs had carried their burden at the totality of circumstances stage. The court observed that elections in Alabama were racially polarized, that black Alabamians enjoy virtually zero success in statewide elections, that political campaigns in Alabama had been characterized by overt or subtle racial appeals, and that Alabama's extensive history of repugnant racial and voting-related discrimination is undeniable and well documented. We see no reason to disturb the district court's careful factual findings, which are subject to clear error review and have gone unchallenged by Alabama in any event. Nor is there a basis to upset the district court's legal conclusions. The court faithfully applied our precedents and correctly determined that, under existing law, HB 1 violated Section 2. The heart of these cases is not about the law as it exists. It is about Alabama's attempt to remake our Section 2 jurisprudence anew. The centerpiece of the state's effort is what it calls the race-neutral benchmark. The theory behind it is this: using modern computer technology, map makers can now generate millions of possible districting maps for a given state. The maps can be designed to comply with traditional districting criteria but to not consider race. The map maker can determine how many majority-minority districts exist in each map, and can then calculate the median or average number of majority-minority districts in the entire multimillion map set. That number is called the race-neutral benchmark. The state contends that this benchmark should serve as the point of comparison in Section 2 cases. The benchmark, the state says, was derived from maps that were race-blind maps that cannot have denied or abridged anyone's right to vote on account of race, because they never took race into account in the first place. Courts in Section 2 cases should therefore compare the number of majority-minority districts in the state's plan to the benchmark. If those numbers are similar, if the state's map resembles the benchmark in this way, then, Alabama argues, the state's map also cannot have denied or abridged anyone's right to vote on account of race. Alabama contends that its approach should be adopted for two reasons. First, the state argues that a race-neutral benchmark best matches the text of the Voting Rights Act. Section 2 requires that the political processes be equally open. What that means, the state asserts, is that the state's map cannot impose obstacles or burdens that block or seriously hinder voting on account of race. These obstacles do not exist, in the state's view, where its map resembles a map that never took race into account. Second, Alabama argues that the Gingles framework ends up requiring racial proportionality in districting. According to the state, Gingles demands that where another majority black district could be drawn, it must be drawn. And that sort of proportionality, Alabama continues, is inconsistent with the compromise that Congress struck, with the text of Section 2, and with the Constitution's prohibition on racial discrimination in voting. To apply the race-neutral benchmark in practice, Alabama would require Section 2 plaintiffs to make at least three showings. First, the illustrative plan that plaintiffs adduce for the first Gingles precondition cannot have been based on race. Second, plaintiffs must show at the totality of circumstances stage that the state's enacted plan diverges from the average plan that would be drawn without taking race into account. And finally, plaintiffs must ultimately prove that any deviation between the state's plan and a race-neutral plan is explainable only by race, not, for example, by the state's naturally occurring geography and demography. As we explain below, we find Alabama's new approach to Section 2 compelling neither in theory nor in practice. We accordingly decline to recast our Section 2 case law as Alabama requests. Section 2 prohibits states from imposing any standard, practice, or procedure in a manner which results in a denial or abridgment of the right of any citizen to vote on account of race or color. What that means is that the political processes in the state must be equally open, such that minority voters do not have less opportunity than other members of the electorate to participate in the political process and to elect representatives of their choice. We have understood the language of Section 2 against the background of the hard-fought compromise that Congress struck. To that end, we have reiterated that Section 2 turns on the presence of discriminatory effects, not discriminatory intent. And we have explained that it is patently clear that Congress has used the words on account of race or color in the Act to mean with respect to race or color, and not to connote any required purpose of racial discrimination. Individuals thus lack an equal opportunity to participate in the political process when a state's electoral structure operates in a manner that minimizes or cancels out their voting strength. That occurs where an individual is disabled from entering into the political process in a reliable and meaningful manner in the light of past and present reality, political and otherwise. A district is not equally open. In other words, when minority voters face, unlike their majority peers, block voting along racial lines, arising against the backdrop of substantial racial discrimination within the state, that renders a minority vote unequal to a vote by a non-minority voter. The state's reading of Section 2, by contrast, runs headlong into our precedent. Alabama asserts that a state's map does not abridge a person's right to vote on account of race if the map resembles a sufficient number of race-neutral alternatives. But our cases have consistently focused, for purposes of litigation, on the specific illustrative maps that a plaintiff adduces. Deviation from that map shows it is possible that the state's map has a disparate effect on account of race. The remainder of the Gingles test helps determine whether that possibility is reality, by looking to polarized voting preferences and the frequency of racially discriminatory actions taken by the state, past and present. A state's liability under Section 2, moreover, must be determined based on the totality of circumstances. Yet Alabama suggests there is only one circumstance that matters: how the state's map stacks up relative to the benchmark. That single-minded view of Section 2 cannot be squared with the VRA's demand that courts employ a more refined approach. And we decline to adopt an interpretation of Section 2 that would revise and reformulate the Gingles threshold inquiry that has been the baseline of our Section 2 jurisprudence for nearly 40 years. Alabama also argues that the race-neutral benchmark is required because our existing Section 2 jurisprudence inevitably demands racial proportionality in districting, contrary to the last sentence of Section 2b. But properly applied, the Gingles framework itself imposes meaningful constraints on proportionality, as our decisions have frequently demonstrated. In Shaw v. Reno, for example, we considered the permissibility of a second majority-minority district in North Carolina, which at the time had 12 seats in the U.S. House of Representatives and a 20% black voting age population. The second majority-minority district North Carolina drew was 160 miles long and, for much of its length, no wider than the interstate corridor. The district wound in snake-like fashion through tobacco country, financial centers, and manufacturing areas, until it gobbled in enough enclaves of black neighborhoods. Indeed, the district was drawn so imaginatively that one state legislator remarked, "If you drove down the interstate with both car doors open, you'd kill most of the people in the district." Though North Carolina believed the additional district was required by Section 2, we rejected that conclusion, finding instead that those challenging the map stated a claim of impermissible racial gerrymandering under the Equal Protection Clause. In so holding, we relied on the fact that the proposed district was not reasonably compact. North Carolina had concentrated a dispersed minority population in a single district by disregarding traditional districting principles such as compactness, contiguity, and respect for political subdivisions, and a reapportionment plan that includes in one district individuals who belong to the same race, but who are otherwise separated by geographical and political boundaries, we said, raised serious constitutional concerns. The same theme emerged in our 1995 decision Miller v. Johnson, where we upheld a district court's finding that one of Georgia's 10 congressional districts was the product of an impermissible racial gerrymander. At the time, Georgia's black voting age population was 27%, but there was only one majority-minority district. To comply with the VRA, Georgia thought it necessary to create 2 more majority-minority districts, achieving proportionality. But like North Carolina and Shaw, Georgia could not create the districts without flouting traditional criteria. One district centered around 4 discrete, widely spaced urban centers that had absolutely nothing to do with each other, and stretched the district hundreds of miles across rural counties and narrow swamp corridors. Geographically, we said of the map, it is a monstrosity. In Bush v. Vera, a plurality of the court again explained how traditional districting criteria limited any tendency of the VRA to compel proportionality. The case concerned Texas's creation of 3 additional majority-minority districts. Though the districts brought the state closer to proportional representation, we nevertheless held that they constituted racial gerrymanders in violation of the 14th Amendment. That was because the districts had no integrity in terms of traditional, neutral redistricting criteria. One of the majority black districts consisted of narrow and bizarrely shaped tentacles. The proposed majority Hispanic district resembled a sacred Mayan bird with spindly legs reaching south and a plumed head rising northward. The point of all this is a simple one. Forcing proportional representation is unlawful and inconsistent with this court's approach to implementing Section 2. The numbers bear the point out well. At the congressional level, the fraction of districts in which black preferred candidates are likely to win is currently below the black share of the eligible voter population in every state but 3. Only one state in the country, meanwhile, has attained a proportional share of districts in which Hispanic preferred candidates are likely to prevail. That is because as residential segregation decreases, as it has sharply done since the 1970s, satisfying traditional districting criteria such as the compactness requirement becomes more difficult. Indeed, as amici supporting the appellees emphasize, Section 2 litigation in recent years has rarely been successful for just that reason. Since 2010, Plaintiffs nationwide have apparently succeeded in fewer than 10 Section 2 suits, and the only state legislative or congressional districts that were redrawn because of successful Section 2 challenges were a handful of state house districts near Milwaukee and Houston. By contrast, numerous lower courts have upheld districting maps where, due to minority populations' geographic diffusion, plaintiffs couldn't design an additional majority-minority district or satisfy the compactness requirement. The same has been true of recent litigation in this court. Reapportionment, we have repeatedly observed, is primarily the duty and responsibility of the states, not the federal courts. Properly applied, the Gingles factors help ensure that remains the case. As respondents themselves emphasize, Section 2 never requires adoption of districts that violate traditional redistricting principles. Its exacting requirements instead limit judicial intervention to those instances of intensive racial politics where the excessive role of race in the electoral process denies minority voters equal opportunity to participate. Although we are content to reject Alabama's invitation to change existing law on the ground that the state misunderstands Section 2 and our decisions implementing it, we also address how the race-neutral benchmark would operate in practice. Alabama's approach fares poorly on that score, which further counsels against our adopting it. The first change to existing law that Alabama would require is prohibiting the illustrative maps that plaintiffs submit to satisfy the first Gingles precondition from being based on race. Although Alabama is not entirely clear whether, under its view, plaintiffs' illustrative plans must not take race into account at all, or whether they must just not prioritize race, we see no reason to impose such a new rule. When it comes to considering race in the context of districting, we have made clear that there is a difference between being aware of racial considerations and being motivated by them. The former is permissible, the latter is usually not. That is because redistricting legislatures will almost always be aware of racial demographics, but such race consciousness does not lead inevitably to impermissible race discrimination. Section 2 itself demands consideration of race. The question whether additional majority-minority districts can be drawn, after all, involves a quintessentially race-conscious calculus. At the same time, however, race may not be the predominant factor in drawing district lines unless there is a compelling reason. Race predominates in the drawing of district lines, our cases explain, when race-neutral considerations come into play only after the race-based decision had been made. That may occur where race for its own sake is the overriding reason for choosing one map over others. While the line between racial predominance and racial consciousness can be difficult to discern, it was not breached here. The Castor plaintiffs relied on illustrative maps produced by expert Bill Cooper. Cooper testified that while it was necessary for him to consider race, he also took several other factors into account, such as compactness, contiguity, and population equality. Cooper testified that he gave all these factors equal weighting, and when asked squarely whether race predominated in his development of the illustrative plans, Cooper responded, "No, it was a consideration. This is a Section 2 lawsuit after all, but it did not predominate or dominate." The district court agreed. It found Cooper's testimony highly credible, and commended Cooper for working hard to give equal weight to all traditional redistricting criteria. The court also explained that Alabama's evidence of racial predominance in Cooper's maps was exceedingly thin. Alabama's expert, Thomas Bryan, testified that he never reviewed the exhibits to Mr. Cooper's report, and that he never reviewed one of the illustrative plans that Cooper submitted. Bryan further testified that he could offer no conclusions or opinions as to the apparent basis of any individual line drawing decisions in Cooper's illustrative plans. By his own admission, Bryan's analysis of any race predominance in Cooper's maps was pretty light. The district court did not err in finding that race did not predominate in Cooper's maps in light of the evidence before it. The dissent contends that race nevertheless predominated in both Cooper's and Duchin's maps, because they were designed to hit express racial targets, namely, 50% plus majority black districts. This argument fails in multiple ways. First, the dissent's reliance on a previous case is mistaken. In that case, this court was unwilling to conclude that a state's maps were produced in a racially predominant manner. Instead, we remanded for the lower court to conduct the predominance analysis itself, explaining that the use of an express racial target was just one factor among others that the court would have to consider as part of a holistic analysis. Justice Thomas dissented in relevant part, contending that because the legislature sought to achieve a black voting age population of at least 55%, race necessarily predominated in its decision-making. But the court did not join in that view, and Justice Thomas again dissents along the same lines today. The second flaw in the dissent's proposed approach is its inescapable consequence. Gingles must be overruled. According to the dissent, racial predominance plagues every single illustrative map ever adduced at the first step of Gingles. For all those maps were created with an express target in mind, they were created to show, as our cases require, that an additional majority-minority district could be drawn. That is the whole point of the enterprise. The upshot of the approach the dissent urges is not to change how Gingles is applied, but to reject its framework outright. The contention that mapmakers must be entirely blind to race has no footing in our Section 2 case law. The line that we have long drawn is between consciousness and predominance. Plaintiffs adduced at least one illustrative map that comported with our precedents. They were required to do no more to satisfy the first step of Gingles. The next condition Alabama would graft onto Section 2 is a requirement that plaintiffs demonstrate, at the totality of circumstances stage, that the state's enacted plan contains fewer majority-minority districts than the race-neutral benchmark. If it does not, then Section 2 should drop out of the picture. Alabama argues that is what should have happened here. It notes that one of plaintiffs' experts, Dr. Dushan, used an algorithm to create 2 million districting plans for Alabama, without taking race into account in any way in the generation process. Of these 2 million race-blind plans, none contained 2 majority black districts, while many plans did not contain any. Alabama also points to a race-neutral computer simulation conducted by another one of plaintiffs' experts, Dr. Kosuke Imai, which produced 30,000 potential maps. As with Dr. Dushan's maps, none of the maps that Dr. Imai created contained 2 majority black districts. Alabama thus contends that because HB1 sufficiently resembles the race-neutral maps created by Dr. Dushan and Dr. Imai, all of the maps lack 2 majority black districts. HB1 does not violate Section 2. Alabama's reliance on the maps created by Dr. Dushan and Dr. Imai is misplaced. For one, neither Dushan's nor Imai's maps accurately represented the districting process in Alabama. Dr. Dushan's maps were based on old census data, from 2010 instead of 2020, and ignored certain traditional districting criteria, such as keeping together communities of interest, political subdivisions, or municipalities. And Dr. Imai's 30,000 maps failed to incorporate Alabama's own districting guidelines, including keeping together communities of interest and preserving municipal boundaries. But even if the maps created by Dr. Dushan and Dr. Imai were adequate comparators, we could not adopt the map comparison test that Alabama proposes. The test is flawed in its fundamentals. Districting involves myriad considerations: compactness, contiguity, political subdivisions, natural geographic boundaries, county lines, pairing of incumbents, communities of interest, and population equality. Yet quantifying, measuring, prioritizing, and reconciling these criteria requires map drawers to make difficult, contestable choices. And it is easy to imagine how different criteria could move the median map toward different distributions, meaning that the same map could be lawful or not depending solely on what the mapmakers said they set out to do. For example, the scientific literature contains dozens of competing metrics on the issue of compactness. Which one of these metrics should be used? What happens when the maps they produce yield different benchmark results? How are courts to decide? Alabama does not say. It offers no rule or standard for determining which of these choices are better than others. Nothing in Section 2 provides an answer either. In 1982, the computerized map-making software that Alabama contends plaintiffs must use to demonstrate an unspecified level of deviation did not even exist. And neither the text of Section 2 nor the fraught debate that produced it suggests that equal access to the fundamental right of voting turns on computer simulations that are technically complicated, expensive to produce, and available to only a small cadre of university researchers that have the resources and expertise to run them. One final point bears mentioning. Throughout these cases, Alabama has repeatedly emphasized that HB1 cannot have violated Section 2, because none of plaintiffs' 2 million-odd maps contained more than one majority-minority district. The point is that 2 million is a very big number and that sheer volume matters. But as elsewhere, Alabama misconceives the math project that it expects courts to oversee. A brief submitted by 3 computational redistricting experts explains that the number of possible districting maps in Alabama is at least in the trillions. Another publication reports that the number of potential maps may be orders of magnitude higher, the universe of all possible connected, population-balanced districting plans that satisfy the state's requirements, it explains, is likely in the range of Google's. 2 million maps, in other words, is not many maps at all. And Alabama's insistent reliance on that number, however powerful it may sound in the abstract, is thus close to irrelevant in practice. What would the next million maps show? The next billion? The first trillion of the trillions? Answerless questions all. Section 2 cannot require courts to judge a contest of computers when there is no reliable way to determine who wins, or even where the finish line is. Alabama's final contention, with respect to the race-neutral benchmark, is that it requires plaintiffs to demonstrate that any deviations between the state's enacted plan and race-neutral alternatives can be explained only by racial discrimination. We again find little merit in Alabama's proposal. As we have already explained, our precedents and the legislative compromise struck in the 1982 amendments clearly rejected treating discriminatory intent as a requirement for liability under Section 2. Yet Alabama's proposal is even more demanding than the intent test Congress jettisoned. Demonstrating discriminatory intent, we have long held, does not require a plaintiff to prove that the challenged action rested solely on racially discriminatory purposes. Alabama's proposed approach stands in sharp contrast to all this, injecting into the effects test of Section 2, an evidentiary standard that even our purposeful discrimination cases eschew. Alabama finally asserts that the court should outright stop applying Section 2 in cases like these, because the text of Section 2 does not apply to single-member redistricting, and because Section 2 is unconstitutional as the district court applied it here. We disagree on both counts. Alabama first argues that Section 2 does not apply to single-member redistricting. Echoing Justice Thomas's concurrence in Holder v. Hall, Alabama, reads Section 2's reference to standard practice or procedure to mean only the methods for conducting a part of the voting process that might be used to interfere with a citizen's ability to cast his vote. Examples of covered activities would include registration requirements, the locations of polling places, the times polls are open, the use of paper ballots as opposed to voting machines, and other similar aspects of the voting process, but not a single-member districting system or the selection of one set of districting lines over another. This understanding of Section 2 cannot be reconciled with our precedent. As recounted above, we have applied Section 2 to states' districting maps in an unbroken line of decisions stretching 4 decades. In doing so, we have unanimously held that Section 2 and Gingles certainly apply to claims challenging single-member districts, and we have even invalidated portions of a state's single-district map under Section 2. Alabama's approach would require abandoning this precedent, overruling the interpretation of Section 2 as set out in nearly a dozen of our cases. We decline to take that step. Congress is undoubtedly aware of our construing Section 2 to apply to districting challenges. It can change that if it likes, but until and unless it does, statutory stare decisis counsels are staying the course. The statutory text in any event supports the conclusion that Section 2 applies to single-member districts. Alabama's own proffered definition of a procedure is the manner or method of proceeding in a process or course of action. But the manner of proceeding in the act of voting entails determining in which districts voters will vote. The fact that the term procedure is preceded by the phrase qualification or prerequisite to voting does not change its meaning. It is hard to imagine many more fundamental prerequisites to voting than determining where to cast your ballot, or who you are eligible to vote for. Perhaps for that reason, even Alabama does not bear the courage of its conviction on this point. It refuses to argue that Section 2 is inapplicable to multi-member districting, though its textual arguments apply with equal force in that context. The dissent, by contrast, goes where even Alabama does not dare, arguing that Section 2 is wholly inapplicable to districting, because it focuses on ballot access and counting only. But the statutory text upon which the dissent relies supports the exact opposite conclusion. The relevant section provides that the terms vote or voting shall include all action necessary to make a vote effective. Those actions include, but are not limited to, actions required by law prerequisite to voting, casting a ballot, and having such ballot counted properly and included in the appropriate totals of votes cast. It would be anomalous to read the broad language of the statute, all action necessary, including but not limited to have the crabbed reach that Justice Thomas posits. And we have already discussed why determining where to cast a ballot constitutes a prerequisite to voting, as the statute requires. The dissent also contends that applying Section 2 to districting rests on systematic neglect of the ballot access focus of the 1960s voting rights struggles. But history did not stop in 1960. As we have explained, Congress adopted the amended Section 2 in response to the 1980 decision City of Mobile, a case about districting. And, as the dissent itself acknowledges, Congress drew Section 2B's current operative language from the 1973 decision White v. Register, a case that was also about districting. In fact, a case that invalidated 2 multi-member districts in Texas and ordered them redrawn into single-member districts. This was not lost on anyone when Section 2 was amended. Indeed, it was the precise reason that the contentious debates over proportionality raged, debates that would have made little sense if Section 2 covered only poll taxes and the like, as the dissent contends. We also reject Alabama's argument that Section 2 as applied to redistricting is unconstitutional under the 15th Amendment. According to Alabama, that amendment permits Congress to legislate against only purposeful discrimination by states. But we held over 40 years ago that, even if Section 1 of the 15th Amendment prohibits only purposeful discrimination, the prior decisions of this court foreclose any argument that Congress may not, pursuant to Section 2 of the 15th Amendment, outlaw voting practices that are discriminatory in effect. The VRA's ban on electoral changes that are discriminatory in effect, we emphasized, is an appropriate method of promoting the purposes of the 15th Amendment. As City of Rome recognized, we had reached the very same conclusion in South Carolina v. Katzenbach, a decision issued right after the VRA was first enacted. Alabama further argues that, even if the 15th Amendment authorizes the effects test of Section 2, that amendment does not authorize race-based redistricting as a remedy for Section 2 violations. But for the last 4 decades, this court and the lower federal courts have repeatedly applied the effects test of Section 2 as interpreted in Gingles, and, under certain circumstances, have authorized race-based redistricting as a remedy for state districting maps that violate Section 2. In light of that precedent, including City of Rome, we are not persuaded by Alabama's arguments that Section 2 as interpreted in Gingles exceeds the remedial authority of Congress. The concern that Section 2 may impermissibly elevate race in the allocation of political power within the states is, of course, not new. Our opinion today does not diminish or disregard these concerns. It simply holds that a faithful application of our precedents and a fair reading of the record before us do not bear them out here. The judgments of the District Court for the Northern District of Alabama in the Castor case, and of the 3-judge District Court in the Milligan case, are affirmed. It is so ordered. Justice Kavanaugh, concurring in all but Part 3, B1. I agree with the court that Alabama's redistricting plan violates Section 2 of the Voting Rights Act as interpreted in Thornburg v. Gingles. I write separately to emphasize 4 points. First, the upshot of Alabama's argument is that the court should overrule Gingles, but the stare decisis standard for this court to overrule a statutory precedent, as distinct from a constitutional precedent, is comparatively strict. Unlike with constitutional precedents, Congress and the President may enact new legislation to alter statutory precedents such as Gingles. In the past 37 years, however, Congress and the President have not disturbed Gingles, even as they have made other changes to the Voting Rights Act. Although statutory stare decisis is not absolute, the court has ordinarily left the updating or correction of erroneous statutory precedents to the legislative process. Second, Alabama contends that Gingles inevitably requires a proportional number of majority-minority districts, which in turn contravenes the proportionality disclaimer in Section 2B of the Voting Rights Act. But Alabama's premise is wrong. As the court's precedents make clear, Gingles does not mandate a proportional number of majority-minority districts. Gingles requires the creation of a majority-minority district only when, among other things, 1. A state's redistricting map cracks or packs a large and geographically compact minority population, and 2. A plaintiff's proposed alternative map and proposed majority-minority district are reasonably configured, namely, by respecting compactness principles and other traditional districting criteria such as county, city, and town lines. If Gingles demanded a proportional number of majority-minority districts, states would be forced to group together geographically dispersed minority voters into unusually shaped districts, without concern for traditional districting criteria such as county, city, and town lines. But Gingles and this court's later decisions have flatly rejected that approach. Third, Alabama argues that courts should rely on race-blind computer simulations of redistricting maps to assess whether a state's plan abridges the right to vote on account of race. It is true that computer simulations might help detect the presence or absence of intentional discrimination. For example, if all of the computer simulations generated only one majority-minority district, it might be difficult to say that a state had intentionally discriminated on the basis of race by failing to draw a second majority-minority district. But as this court has long recognized, and as all members of this court today agree, the text of Section 2 establishes an effects test, not an intent test, and the effects test, as applied by Gingles to redistricting, requires in certain circumstances that courts account for the race of voters so as to prevent the cracking or packing, whether intentional or not, of large and geographically compact minority populations. Fourth, Alabama asserts that Section 2, as construed by Gingles to require race-based redistricting in certain circumstances, exceeds Congress's remedial or preventive authority under the 14th and 15th Amendments. As the court explains, the constitutional argument presented by Alabama is not persuasive in light of the court's precedents. Justice Thomas notes, however, that even if Congress in 1982 could constitutionally authorize race-based redistricting under Section 2 for some period of time, the authority to conduct race-based redistricting cannot extend indefinitely into the future. But Alabama did not raise that temporal argument in this court, and I therefore would not consider it at this time. For those reasons, I vote to affirm, and I concur in all but Part 3, B1 of the court's opinion. Justice Thomas, with whom Justice Gorsuch joins, with whom Justice Barrett joins as to Parts 2 and 3, and with whom Justice Alito joins as to Parts 2, A and 2, B, dissenting. These cases are yet another installment in the disastrous misadventure of this court's voting rights jurisprudence. What distinguishes them is the uncommon clarity with which they lay bare the gulf between our colorblind Constitution and the consciously segregated districting system currently being constructed in the name of the Voting Rights Act. The question presented is whether Section 2 of the Act, as amended, requires the state of Alabama to intentionally redraw its long-standing congressional districts so that black voters can control a number of seats roughly proportional to the black share of the state's population. Section 2 demands no such thing, and, if it did, the Constitution would not permit it. At the outset, I would resolve these cases in a way that would not require the federal judiciary to decide the correct racial apportionment of Alabama's congressional seats. Under the statutory text, a Section 2 challenge must target a voting qualification or prerequisite to voting or standard, practice, or procedure. I have long been convinced that those words reach only enactments that regulate citizens' access to the ballot or the processes for counting a ballot. They do not include a state's choice of one districting scheme over another. Thus, Section 2 cannot provide a basis for invalidating any district. While I will not repeat all the arguments that led me to this conclusion nearly 3 decades ago, the court's belated appeal to the statutory text is not persuasive. Whatever words like practice and procedure are capable of meaning in a vacuum, the prohibitions of Section 2 apply to practices and procedures that affect voting and the right to vote. Vote and voting are defined terms under the Act, and the Act's definition plainly focuses on ballot access and counting. The terms vote or voting shall include all action necessary to make a vote effective in any primary, special or general election, including but not limited to registration, listing pursuant to this chapter, or other action required by law prerequisite to voting, casting a ballot, and having such ballot counted properly and included in the appropriate totals of votes cast with respect to candidates for public or party office, and propositions for which votes are received in an election. In enacting the original Voting Rights Act in 1965, Congress copied this definition almost verbatim from Title VI of the Civil Rights Act of 1960, a law designed to protect access to the ballot in jurisdictions with patterns or practices of denying such access based on race, and which cannot be construed to authorize so-called vote dilution claims. Title I of the Civil Rights Act of 1964, which cross-referenced the 1960 Act's definition of vote, likewise protects ballot access alone and cannot be read to address vote dilution. Tellingly, the 1964 Act also used the words standard, practice, or procedure to refer specifically to voting qualifications for individuals and the actions of state and local officials in administering such requirements. Our entire enterprise of applying Section 2 to districting rests on systematic neglect of these statutory antecedents, and, more broadly, of the ballot access focus of the 1960s voting rights struggles. Moreover, the majority drastically overstates the stare decisis support for applying Section 2 to single-member districting plans like the one at issue here. As the majority implicitly acknowledges, this court has only applied Section 2 to invalidate one single-member district in one case, and no party in that case argued that the plaintiff's vote dilution claim was not cognizable. As for Groh v. Emerson, it held only that the threshold preconditions for challenging multi-member and at-large plans must limit challenges to single-member districts with at least the same force, as it would be peculiar if a vote dilution challenge to the more dangerous multi-member district required a higher threshold showing than a vote fragmentation challenge to a single-member district. Groh did not consider, or, thus, reject, an argument that Section 2 does not apply to single-member districts. In any event, stare decisis should be no barrier to reconsidering a line of cases that was based on a flawed method of statutory construction from its inception, has proved incapable of principled application after nearly 4 decades of experience, and puts federal courts in the business of methodically carving the country into racially designated electoral districts. This court has never applied stare decisis mechanically to prohibit overruling our earlier decisions determining the meaning of statutes, and it should not do so here. Stare decisis did not save separate but equal, despite its repeated reaffirmation in this court, and the pervasive reliance states had placed upon it for decades. It should not rescue modern-day forms of de jure racial balkanization, which, as these cases show, is exactly where our Section 2 vote dilution jurisprudence has led. Even if Section 2 applies here, however, Alabama should prevail. The district court found that Alabama's congressional districting map dilutes black residents' votes because, while it is possible to draw 2 majority black districts, Alabama's map only has 1. But the critical question in all vote dilution cases is, diluted relative to what benchmark? Neither the district court nor the majority has any defensible answer. The text of Section 2 and the logic of vote dilution claims require a meaningfully race-neutral benchmark, and no race-neutral benchmark can justify the district court's finding of vote dilution in these cases. The only benchmark that can justify it, and the one that the district court demonstrably applied, is the decidedly non-neutral benchmark of proportional allocation of political power based on race. As we have long recognized, the very concept of vote dilution implies, and indeed, necessitates, the existence of an undiluted practice against which the fact of dilution may be measured. In a challenge to a districting plan, a court must be able to compare a state's enacted plan with a hypothetical, undiluted plan, ascertained by an objective and workable standard. To be sure, it is no easy task to identify an objective, undiluted benchmark against which to judge a districting plan. As we recently held in the analogous context of partisan gerrymandering, federal courts are not equipped to apportion political power as a matter of fairness. Yet Section 2 vote dilution cases require nothing less. If Section 2 prohibited only intentional racial discrimination, there would be no difficulty in finding a clear and workable rule of decision. But the results test that Congress wrote into Section 2 to supersede Mobile v. Bolden eschews intent as the criterion of liability. Accordingly, a Section 2 vote dilution claim does not simply ask for the elimination of a racial classification. It asks instead for a fair share of political power and influence, with all the justiciability conundrums that entails. Nevertheless, if Section 2 applies to single-member districts, we must accept that some objective and workable standard for choosing a reasonable benchmark exists. Otherwise, single-member districts cannot be challenged as dilutive under Section 2. Given the diverse circumstances of different jurisdictions, it would be fanciful to expect a one-size-fits-all definition of the appropriate benchmark. One overriding principle, however, should be obvious. A proper districting benchmark must be race-neutral. It must not assume, a priori, that an acceptable plan should include any particular number or proportion of minority-controlled districts. I begin with Section 2's text. As relevant here, Section 2A prohibits a state from imposing or applying any electoral rule in a manner which results in a denial or abridgment of the right to vote on account of race or color. Section 2B then provides that Section 2A is violated if, based on the totality of circumstances, the political processes leading to nomination or election in the state are not equally open to participation by members of a protected class, in that its members have less opportunity than other members of the electorate to participate in the political process and to elect representatives of their choice. The extent to which members of a protected class have been elected to office in the state, provided that nothing in this section establishes a right to have members of a protected class elected in numbers equal to their proportion in the population. As we held 2 terms ago in Brnovich, the equal openness requirement is the core and touchstone of Section 2B, with equal opportunity serving an ancillary function. Relying significantly on Section 2B's disclaimer of a right to proportional representation, we also held that Section 2 does not enact a freewheeling disparate impact regime. Brnovich further stressed the value of benchmarks with which challenged electoral rules can be compared, and that a meaningful comparison is essential in judging the significance of any challenged scheme's racially disparate impact. To the extent Section 2 applies to districting plans, then it requires that they be equally open to participation by voters of all races, but it is not a pure disparate impact statute and does not guarantee proportional representation. In its main argument here, Alabama simply carries these principles to their logical conclusion. Any vote dilution benchmark must be race-neutral. Whatever equal openness means in the context of single-member districting, no meaningful comparison is possible using a benchmark that builds in a presumption in favor of minority-controlled districts. Indeed, any benchmark other than a race-neutral one would render the vote dilution inquiry fundamentally circular, allowing courts to conclude that a districting plan dilutes a minority's voting strength on account of race, merely because it does not measure up to an ideal already defined in racial terms. Such a question-begging standard would not answer our precedent's demand for an objective, reasonable benchmark, nor could any non-neutral benchmark be reconciled with Brnovich's rejection of a disparate impact regime or the text disclaimer of a right to proportional representation. There is yet another compelling reason to insist on a race-neutral benchmark. The Constitution abhors classifications based on race. Redistricting is no exception. Just as the state may not, absent extraordinary justification, segregate citizens on the basis of race in its public parks, buses, golf courses, beaches, and schools, the state also may not separate its citizens into different voting districts on the basis of race. Districting maps that sort voters on the basis of race are by their very nature odious. Accordingly, our precedents apply strict scrutiny whenever race was the predominant factor motivating the placement of a significant number of voters within or without a particular district. Or, put another way, whenever race was the criterion that could not be compromised in a district's formation. Because racial gerrymandering, even for remedial purposes, may balkanize us into competing racial factions and undermine the goal of a political system in which race no longer matters. Our cases have long recognized the need to interpret Section 2 to avoid unnecessarily infusing race into virtually every redistricting plan. Plainly, however, that infusion is the inevitable result of any race-based benchmark. Any interpretation of Section 2 that permits courts to condemn enacted districting plans as dilutive relative to a non-neutral benchmark would result in a substantial increase in the number of mandatory districts drawn with race as the predominant factor motivating the legislature's decision, thus raising serious constitutional questions. To avoid setting Section 2 on a collision course with the Constitution, courts must apply a race-neutral benchmark in assessing any claim that a districting plan unlawfully dilutes a racial minority's voting strength. The plaintiffs in these cases seek a proportional allocation of political power according to race. According to the 2020 census, Black Alabamians account for 27.16% of the state's total population and 25.9% of its voting-age population. Both figures slightly less than 2/7 of Alabama's 7 existing congressional districts. 1, District 7, is majority black. These cases were brought to compel the creation of 2 majority-minority congressional districts, roughly proportional control. Plaintiffs seek an order, ordering a congressional redistricting plan that includes 2 majority black congressional districts. Remarkably, the majority fails to acknowledge that 2 minority-controlled districts would mean proportionality, or even that Black Alabamians are about 2/7 of the state. Yet that context is critical to the issues before us, not least because it explains the extent of the racial sorting the plaintiff's goal would require. As a matter of mathematics, single-member districting tends to deal out representation far short of proportionality to virtually all minorities, from environmentalists in Alaska to Republicans in Massachusetts. As such, creating 2 majority black districts would require Alabama to aggressively sort voters on the basis of race. The plaintiff's 11 illustrative maps make that clear. All 11 maps refashion existing District 2 into a majority black district, while preserving the current black majority in District 7. They all follow the same approach, starting with majority black areas of populous Montgomery County. They expand District 2 east and west to encompass predominantly majority black areas throughout the rural Black Belt. In the process, the plans are careful to leave enough of the Black Belt for District 7 to maintain its black majority. Then, and critically, the plans have District 2 extend a southwestern tendril into Mobile County to capture a dense, high-population majority black cluster in urban Mobile. Those black Mobilians currently reside in the urban heart of District 1. For 50 years, District 1 has occupied the southwestern pocket of Alabama, consisting of the state's 2 populous Gulf Coast counties, Mobile and Baldwin, as well as some less populous areas to the immediate north and east. It is indisputable that the Gulf Coast region is the sort of community of interest that the Alabama legislature might reasonably think a congressional district should be built around. It contains Alabama's only coastline, its 4th largest city, and the Port of Mobile. Its physical geography runs north along the Alabama and Mobile rivers, whose paths District 1 follows. Its economy is tied to the Gulf, to shipping, shipbuilding, tourism, and commercial fishing. But, for the plaintiffs to secure their majority black District 2, this long-standing, compact and eminently sensible district must be radically transformed. In the Gulf Coast region, the newly drawn District 1 would retain only the majority white areas that District 2 did not absorb on its path to Mobile's large majority black population. To make up the lost population, District 1 would have to extend eastward through largely majority white rural counties along the length of Alabama's border with the Florida Panhandle. The plaintiffs do not assert that white residents on the Gulf Coast have anything special in common with white residents in those communities, and the district court made no such finding. The plaintiffs' maps would thus reduce District 1 to the leftover white communities of the southern fringe of the state, its shape and constituents defined almost entirely by the need to make District 2 majority black, while also retaining a majority black District 7. The plaintiffs' map-making experts left little doubt that their plans prioritized race over neutral districting criteria. Dr. Moon Duchin, who devised 4 of the plans, testified that achieving 2 majority black districts was a non-negotiable principle in her eyes, a status shared only by our precedent's population balance requirement. Only after those 2 non-negotiables were satisfied, did Dr. Duchin then give lower priority to contiguity and compactness. The architect of the other 7 maps, William Cooper, considered minority voting strength a traditional redistricting principle in its own right, and treated the minority population in and of itself as the paramount community of interest in his plans. Statistical evidence also underscored the illustrative map's extreme racial sorting. Another of the plaintiffs' experts, Dr. Kasuke Imai, computer-generated 10,000 districting plans using a race-blind algorithm programmed to observe several objective districting criteria. None of those plans contained even one majority black district. Dr. Imai generated another 20,000 plans using the same algorithm, but with the additional constraint that they must contain at least one majority black district. None of those plans contained a second majority black district, or even a second district with a black voting age population above 40%. In a similar vein, Dr. Duchin testified about an academic study in which she had randomly generated 2 million districting plans for Alabama, using a race-neutral algorithm that gave priority to compactness and contiguity. She found some plans with one majority black district, but never found a second majority black district in 2 million attempts. That it is hard to draw two majority black districts by accident, Dr. Duchin explained, showed the importance of doing so on purpose. The plurality of justices who joined Part 3, BI of the Chief Justice's opinion, appear to agree that the plaintiffs could not prove the first precondition of their statewide vote dilution claim, that black Alabamians could constitute a majority in two reasonably configured districts, by drawing an illustrative map in which race was predominant. That should be the end of these cases, as the illustrative maps here are palpable racial gerrymanders. The plaintiffs' experts clearly applied express racial targets by setting out to create 50% plus majority black districts in both Districts 2 and 7. And it is impossible to conceive of the state adopting the illustrative maps without pursuing the same racially motivated goals. Again, the map's key design features are: 1. Making District 2 majority black by connecting black residents in one metropolitan area, Montgomery, with parts of the rural Black Belt and black residents in another metropolitan area, Mobile. 2. Leaving enough of the Black Belt's majority black rural areas for District 7 to maintain its majority black status. And 3. Reducing District 1 to the white remainder of the southern third of the state. If the state did this, we would call it a racial gerrymander, and rightly so. We would have no difficulty recognizing race as the predominant factor motivating the placement of significant numbers of voters within or without Districts 1, 2, and 7. The stark splits in the racial composition of populations moved into and out of Districts 1 and 2 would make that obvious. So would the manifest absence of any non-racial justification for the new District 1. And so would the state's clear intent to ensure that both Districts 2 and 7 hit their preordained racial targets. That the plan delivered proportional control for a particular minority, a statistical anomaly that over 2 million race-blind simulations did not yield, and 20,000 race-conscious simulations did not even approximate, would be still further confirmation. The state could not justify such a plan simply by arguing that it was less bizarre to the naked eye than other, more elaborate racial gerrymanders we have encountered. As we held in Miller, visual bizarreness is not a necessary element of the constitutional wrong, only persuasive circumstantial evidence. Nor could such a plan be explained by supposed respect for the Black Belt. For present purposes, I accept the district court's finding that the Black Belt is a significant community of interest. But the entire black population of the Black Belt, some 300,000 black residents, is too small to provide a majority in a single congressional district, let alone two. The black residents needed to populate majority black versions of Districts 2 and 7 are overwhelmingly concentrated in the urban counties of Jefferson, i.e., the Birmingham metropolitan area, with about 290,000 black residents, Mobile, about 152,000 black residents, and Montgomery, about 134,000 black residents. Of the three, only Montgomery County is in the Black Belt. The plaintiffs' maps, therefore, cannot and do not achieve their goal of two majority black districts by joining together the Black Belt. Rather, their majority black districts are anchored by three separate high-density clusters of black residents in three separate metropolitan areas, two of them outside the Black Belt. The Black Belt's largely rural remainder is then divided between the two districts to the extent needed to fill out their population numbers with black majorities in both. Respect for the Black Belt as a community of interest cannot explain this approach. The only explanation is the plaintiffs' express racial target, two majority black districts and statewide proportionality. The district court nonetheless found that race did not predominate in the plaintiffs' illustrative maps because Dr. Duchin and Mr. Cooper prioritized race only as necessary to draw two reasonably compact majority black congressional districts, as opposed to maximizing the number of majority black districts, or the BVOP black voting age population in any particular majority black district. This reasoning shows a profound misunderstanding of our racial gerrymandering precedents. As explained above, what triggers strict scrutiny is the intentional use of a racial classification in placing a significant number of voters within or without a particular district. Thus, any plan whose predominant purpose is to achieve a non-negotiable, predetermined racial target in a non-negotiable, predetermined number of districts, is a racial gerrymander subject to strict scrutiny. The precise fraction used as the racial target, and the number of districts it is applied to, are irrelevant. In affirming the district court's non-predominance finding, the plurality glosses over these plain legal errors, and it entirely ignores Dr. Duchin's plans, presumably because her own explanation of her method sounds too much like textbook racial predominance. The plurality thus affirms the district court's finding only in part, and with regard to Mr. Cooper's plans alone. In doing so, the plurality acts as if the only relevant evidence were Mr. Cooper's testimony about his own mental state, and the state's experts' analysis of Mr. Cooper's maps. Such a blinkered view of the issue is unjustifiable. All 11 illustrative maps follow the same approach to creating two majority black districts. The essential design features of Mr. Cooper's maps are indistinguishable from Dr. Duchin's, and it is those very design features that would require race to predominate. None of the plaintiff's maps could possibly be drawn by a mapmaker who was merely aware of, rather than motivated by, racial demographics. They could only ever be drawn by a mapmaker whose predominant motive was hitting the express racial target of two majority black districts. The plurality endeavors in vain to blunt the force of this obvious fact. Contrary to the plurality's apparent understanding, nothing in Bethune-Hill suggests that an express racial target is not highly probative evidence of racial predominance. That the Bethune-Hill majority declined to act as a court of first view, instead leaving the ultimate issue of predominance for remand, cannot be transmuted into such an implausible holding, or, in truth, any holding at all. The plurality is also mistaken that my predominance analysis would doom every illustrative map a Section 2 plaintiff ever adduced. Rather, it would mean only that, because Section 2 requires a race-neutral benchmark, plaintiffs cannot satisfy their threshold burden of showing a reasonably configured alternative plan with a proposal that could only be viewed as a racial gerrymander if enacted by the state. This rule would not bar a showing, in an appropriate case, that a state could create an additional majority-minority district through a reasonable redistricting process in which race did not predominate. It would? On the other hand, screen out efforts to use Section 2 to push racially proportional districting to the limits of what a state's geography and demography make possible. The approach taken by the illustrative maps here. The foregoing analysis should be enough to resolve these cases. If the plaintiffs have not shown that Alabama could create two majority black districts without resorting to a racial gerrymander, they cannot have shown that Alabama's one majority black district map dilutes black Alabamians' voting strength relative to any meaningfully race-neutral benchmark. The inverse, however, is not true. Even if it were possible to regard the illustrative maps as not requiring racial predominance, it would not necessarily follow that a two-majority black district map was an appropriate benchmark. All that might follow is that the illustrative maps were reasonably configured. In other words, that they were consistent with some reasonable application of traditional districting criteria, in which race did not predominate. But, in virtually all jurisdictions, there are countless possible districting schemes that could be considered reasonable in that sense. The mere fact that a plaintiff's illustrative map is one of them cannot justify making it the benchmark against which other plans should be judged. That conceptual gap between reasonable and benchmark is highly relevant here. Suppose, for argument's sake, that Alabama reasonably could decide to create two majority black districts by 1. Connecting Montgomery's black residents with Mobile's black residents, 2. Dividing up the rural parts of the Black Belt between that district and another district with its population core in the majority black parts of the Birmingham area, and 3. Accepting the extreme disruption to District 1 and the Gulf Coast that this approach would require. The plaintiffs prefer that approach because it allows the creation of two majority black districts, which they think Alabama should have. But even if that approach were reasonable, there is hardly any compelling race-neutral reason to elevate such a plan to a benchmark against which all other plans must be measured. Nothing in Alabama's geography or demography makes it clearly the best way, or even a particularly attractive way, to draw 3 of 7 equally populous districts. The state has obvious legitimate, race-neutral reasons to prefer its own map, most notably, its interest in preserving the cores of prior districts and the Gulf Coast community of interest in District 1. And even discounting those interests would not yield a race-neutral case for treating the plaintiff's approach as a suitable benchmark. Absent core retention, there is no apparent race-neutral reason to insist that District 7 remain a majority black district, uniting Birmingham's majority black neighborhoods with majority black rural areas in the Black Belt. Finally, it is surely probative that over 2 million race-neutral simulations did not yield a single plan with two majority black districts, and even 20,000 simulations with a one-majority black district floor did not yield a second district with a black voting age population over 40%. If any plan with two majority black districts would be an outlier within the likely universe of race-neutral districting plans, it is hard to see how the mere possibility of drawing two majority black districts could show that a one-district map diluted black Alabamians' votes relative to any appropriate benchmark. Given all this, by what benchmark did the district court find that Alabama's enacted plan was dilutive? The answer is as simple as it is unlawful. The district court applied a benchmark of proportional control based on race. To be sure, That benchmark was camouflaged by the elaborate vote dilution framework we have inherited from Gingles, but nothing else in that framework or in the district court's reasoning supplies an alternative benchmark capable of explaining the district court's bottom line, that Alabama's one-majority black district map dilutes black voters' fair share of political power. Under Gingles, the majority explains, there are three preconditions to a vote dilution claim. 1. The relevant minority group must be sufficiently large and geographically compact to constitute a majority in a reasonably configured district. 2. The minority group must be politically cohesive. And 3. The majority group must vote sufficiently as a bloc to enable it to defeat the minority's preferred candidates. If these preconditions are satisfied, Gingles instructs courts to consider the totality of the circumstances and to determine, based upon a searching practical evaluation of the past and present reality, whether the political process is equally open to minority voters. The majority gives the impression that, in applying this framework, the district court merely followed a set of well-settled, determinate legal principles, but it is widely acknowledged that Gingles and its progeny have engendered considerable disagreement and uncertainty regarding the nature and contours of a vote dilution claim, with commentators noting the lack of any authoritative resolution of the basic questions one would need to answer to make sense of Section 2's results test. If there is any area of law notorious for its many unsolved puzzles, this is it. The source of this confusion is fundamental. Quite simply, we have never succeeded in translating the Gingles framework into an objective and workable method of identifying the undiluted benchmark. The second and third preconditions are all but irrelevant to the task. They essentially collapse into one question. Is voting racially polarized such that minority-preferred candidates consistently lose to majority-preferred ones? Even if the answer is yes, that tells a court nothing about how hard it should be for minority voters to elect their preferred candidates under an acceptable system. Perhaps an acceptable system is one in which the minority simply cannot elect its preferred candidates. It is, after all, a minority. Rejecting that outcome as dilutive requires a value judgment relative to a benchmark that polarization alone cannot provide. The first Gingles precondition is only marginally more useful. True, the benchmark in a redistricting challenge must be a hypothetical, undiluted plan, and the first precondition at least requires plaintiffs to identify some hypothetical alternative plan. Yet that alternative plan need only be reasonably configured, and, as explained above, to say that a plan is reasonable is a far cry from establishing an objective standard of fairness. That leaves only the Gingles framework's final stage, the totality of circumstances, determination whether a state's political process is equally open to minority voters. But this formulation is mere verbiage unless one knows what an equally open system should look like, in other words, what the benchmark is. And our cases offer no substantive guidance on how to identify the undiluted benchmark at the totality stage. The best they have to offer is a grab bag of amorphous factors widely known as the Senate factors. After the Senate Judiciary Committee report accompanying the 1982 amendments to Section 2, that Gingles said typically may be relevant to a Section 2 claim. Those factors, however, amount to no more than a list of possible considerations that might be consulted by a court attempting to develop a Gestalt view of the political and racial climate in a jurisdiction. Such a Gestalt view is far removed from the necessary benchmark of a hypothetical, undiluted districting plan. To see this, one need only consider the district court's use of the Senate factors here. The court began its totality stage analysis by reiterating what nobody disputes, that voting in Alabama is racially polarized, with black voters overwhelmingly preferring Democrats and white voters largely preferring Republicans. To rebut the state's argument that this pattern is attributable to politics, not race per se, the court noted that Donald Trump, who is white, prevailed over Ben Carson, who is black, in the 2016 Republican presidential primary. Next, the court observed that black candidates rarely win statewide elections in Alabama, and that black state legislators overwhelmingly come from majority-minority districts. The court then reviewed Alabama's history of racial discrimination, noted other voting rights cases in which the state was found liable, and cataloged socioeconomic disparities between black and white Alabamians in everything from car ownership to health insurance coverage. The court attributed these disparities at least in part to the state's history of discrimination, and found that they hinder black residents from participating in politics today, notwithstanding the fact that black and white Alabamians register and turn out to vote at similar rates. Last, the court interpreted a handful of comments by 3 white politicians as racial campaign appeals. In reviewing this march through the Senate factors, it is impossible to discern any overarching standard or central question, only what might be called an impressionistic moral audit of Alabama's racial past and present. No? Is it possible to determine any logical nexus between this audit and the remedy ordered, a congressional districting plan in which black Alabamians can control more than one seat? Given the district court's finding that 2 reasonably configured majority black districts could be drawn, would Alabama's one-district map have been acceptable if Ben Carson had won the 2016 primary, or if a greater number of black Alabamians owned cars? The idea that such factors could explain the district court's judgment line is absurd. The plaintiff's claims pose one simple question: what is the right number of Alabama's congressional seats that black voters who support Democrats should control? Neither the Senate factors nor the Gingles framework as a whole offers any principled answer. In reality, the limits of the Gingles preconditions and the aimlessness of the totality of circumstances inquiry left the district court only one obvious and readily administrable option: a benchmark of allocation of seats in direct proportion to the minority group's percentage in the population. True, as discussed above, that benchmark is impossible to square with what the majority calls Section 2B's robust disclaimer against proportionality, and it runs headlong into grave constitutional problems. Nonetheless, the intuitive pull of proportionality is undeniable. Once one accepts the proposition that the effectiveness of votes is measured in terms of the control of seats, the core of any vote dilution claim is inherently based on ratios between the numbers of the minority in the population and the numbers of seats controlled, and there is no more logical ratio than direct proportionality. Combine that intuitive appeal with the lack of any better alternative identified in our case law to date, and we should not be surprised to learn that proportionality generally explains the results of Section 2 cases after the Gingles preconditions are satisfied. Thus, in the absence of an alternative benchmark, the vote dilution inquiry has a strong and demonstrated tendency to collapse into a rough two-part test. Does the challenged districting plan give the relevant minority group control of a proportional share of seats? 2. If not, has the plaintiff shown that some reasonably configured districting plan could better approximate proportional control? In this approach, proportionality is the ultimate benchmark, and the first Gingles precondition becomes a proxy for whether that benchmark is reasonably attainable in practice. Beneath all the trappings of the Gingles framework, that two-part test describes how the district court applied Section 2 here. The gravitational force of proportionality is obvious throughout its opinion. At the front end, the district court even built proportionality into its understanding of Gingles' first precondition, finding the plaintiff's illustrative maps to be reasonably configured in part because they provided a number of majority black districts, roughly proportional to the black percentage of the population. At the back end, the district court concluded its totality analysis by revisiting proportionality and finding that it weighed decidedly in favor of the plaintiffs. While the district court disclaimed giving overriding significance to proportionality, the fact remains that nothing else in its reasoning provides a logical nexus to its finding of a districting wrong and a need for a districting remedy. Finally, as if to leave no doubt about its implicit benchmark, the court admonished the state that any remedial plan will need to include 2 districts in which black voters either comprise a voting age majority or something quite close. In sum, the district court's thinly disguised benchmark was proportionality. Black Alabamians are about 2/7 of the state's population, so they should control 2 of the state's 7 congressional seats. That was error, perhaps an understandable error given the limitations of the Gingles framework, but error nonetheless. As explained earlier, any principled application of Section 2 to cases such as these requires a meaningfully race-neutral benchmark. The benchmark cannot be an a priori thumb on the scale for racially proportional control. The majority opinion does not acknowledge the district court's express proportionality-based reasoning. That omission is of a piece with its earlier noted failures to acknowledge the well-known indeterminacy of the Gingles framework, that black Alabamians are about 2/7 of the state's population, and that the plaintiffs here are thus seeking statewide proportionality. Through this pattern of omissions, the majority obscures the burning question in these cases. The district court's vote dilution finding can be justified only by a racially loaded benchmark, specifically, a benchmark of proportional control based on race. Is that the benchmark the statute demands? The majority fails to confront this question head-on, and it studiously avoids mentioning anything that would require it to do so. The same non-responsiveness infects the majority's analysis, which is largely devoted to rebutting an argument nobody makes. Contrary to the majority's telling, Alabama does not equate the race-neutral benchmark with the median or average number of majority-minority districts in a large computer-generated set of race-blind districting plans. The state's argument for a race-neutral benchmark is rooted in the text of Section 2, the logic of vote dilution claims, and the constitutional problems with any non-neutral benchmark. It then relies on the computer evidence in these cases, among other facts, to argue that the plaintiffs have not shown dilution relative to any race-neutral benchmark. But the idea that race-neutral benchmark means the composite average of many computer-generated plans is the majority's alone. After thus straw-manning Alabama's arguments at the outset, the majority muddles its own response. In a perfunctory footnote, it disclaims any holding that algorithmic map-making evidence is categorically irrelevant in Section 2 cases. That conclusion, however, is the obvious implication of the majority's reasoning and rhetoric. The majority in effect, if not in word, thus forecloses any meaningful use of computer evidence to help locate the undiluted benchmark. There are two critical problems with this fiat. The first, which the majority seems to recognize yet fails to resolve, is that excluding such computer evidence from view cannot be reconciled with Section 2's command to consider the totality of circumstances. Second, and more fundamentally, the reasons that the majority gives for downplaying the relevance of computer evidence would more logically support a holding that there is no judicially manageable way of applying Section 2's results test to single-member districts. The majority waxes about the myriad considerations that go into districting, the difficult, contestable choices those considerations require, and how nothing in Section 2 provides an answer to the question of how well any given algorithm approximates the correct benchmark. In the end, it concludes, Section 2 cannot require courts to judge a contest of computers in which there is no reliable way to determine who wins, or even where the finish line is. The majority fails to recognize that whether vote dilution claims require an undiluted benchmark is not up for debate. If Section 2 applies to single-member districting plans, courts cannot dispense with an undiluted benchmark for comparison, ascertained by an objective and workable method. Of course, I would be the last person to deny that defining the undiluted benchmark is difficult. But the myriad considerations and answerless questions the majority frets about are inherent in the very enterprise of applying Section 2 to single-member districts. Everything the majority says about the difficulty of defining the undiluted benchmark with computer evidence applies with equal or greater force to the task of defining it without such evidence. At their core, the majority's workability concerns are an isolated demand for rigor against the backdrop of a legal regime that has long been inherently standardless, and must remain so until the court either discovers a principled and objective method of identifying the undiluted benchmark, or abandons this enterprise altogether. Ultimately, the majority has very little to say about the appropriate benchmark. What little it does say suggests that the majority sees no real alternative to the district court's proportional control benchmark, though it appears unwilling to say so outright. For example, in a nod to the statutory text and its equal openness requirement, the majority asserts that a district is not equally open when minority voters face, unlike their majority peers, block voting along racial lines, arising against the backdrop of substantial racial discrimination within the state, that renders a minority vote unequal to a vote by a non-minority voter. But again, we have held that dilution cannot be shown without an objective, undiluted benchmark, and this verbiage offers no guidance for how to determine it. Later, the majority asserts that the Gingles framework itself imposes meaningful constraints on proportionality. But the only constraint on proportionality the majority articulates is that it is often difficult to achieve, which, quite obviously, is no principled limitation at all. Thus, the end result of the majority's reasoning is no different from the district courts. The ultimate benchmark is a racially proportional allocation of seats, and the main question on which liability turns is whether a closer approximation to proportionality is possible under any reasonable application of traditional districting criteria. This approach, moreover, is consistent with how the majority describes the role of plaintiffs' illustrative maps, as well as an unjustified practical asymmetry to which its rejection of computer evidence gives rise. Courts are to focus on the specific illustrative maps that a plaintiff adduces, by which the majority means that courts should not focus on statistical evidence showing those maps to be outliers. Thus, plaintiffs may use an algorithm to generate any number of maps that meet specified districting criteria and a preferred racial target. Then, they need only produce one of those maps to show it is possible that the state's map is dilutive. But the state may not use algorithmic evidence to suggest that the plaintiff's map is an unsuitable benchmark for comparison. Not even, apparently, if it can prove that the illustrative map is an outlier among billions or trillions of concededly adequate comparators. This arbitrary restriction amounts to a thumb on the scale for Section 2 plaintiffs, an unearned presumption that any reasonable map they put forward constitutes a benchmark against which the state's map can be deemed dilutive. And, once the comparison is framed in that way, the only workable rule of decision is proportionality. By affirming the district court, the majority thus approves its benchmark of proportional control limited only by feasibility, and it entrenches the most perverse tendencies of our vote dilution jurisprudence. It guarantees that courts will continue to approach vote dilution claims just as the district court here did, with no principle way of determining how many seats a minority should control, and with a strong temptation to bless every incremental step toward a racially proportional allocation that plaintiffs can pass off as consistent with any reasonable map. As noted earlier, the court has long recognized the need to avoid interpretations of Section 2 that would unnecessarily infuse race into virtually every redistricting, raising serious constitutional questions. Today, however, by approving the plaintiffs' racially gerrymandered maps as reasonably configured, refusing to ground Section 2 vote dilution claims in a race-neutral benchmark, and affirming a vote dilution finding that can only be justified by a benchmark of proportional control, the majority holds, in substance, that race belongs in virtually every redistricting. It thus drives headlong into the very constitutional problems that the court has long sought to avoid. The result of this collision is unmistakable. If the district court's application of Section 2 was correct as a statutory matter, Section 2 is unconstitutional as applied here. Because the Constitution restricts consideration of race and the Voting Rights Act demands consideration of race, strict scrutiny is implicated wherever, as here, Section 2 is applied to require a state to adopt or reject any districting plan on the basis of race. At this point, it is necessary to confront directly one of the more confused notions inhabiting our redistricting jurisprudence. In several cases, we have assumed that compliance with Section 2 of the Voting Rights Act could be a compelling state interest, before proceeding to reject race-predominant plans or districts as insufficiently tailored to that asserted interest. But we have never applied this assumption to uphold a districting plan that would otherwise violate the Constitution, and the slightest reflection on first principles should make clear why it would be problematic to do so. The Constitution is supreme over statutes, not vice versa. Therefore, if complying with a federal statute would require a state to engage in unconstitutional racial discrimination, the proper conclusion is not that the statute excuses the state's discrimination, but that the statute is invalid. If Congress has any power at all to require states to sort voters into congressional districts based on race, that power must flow from its authority to enforce the 14th and 15th Amendments by appropriate legislation. Since Congress in 1982 replaced intent with effects as the criterion of liability, however, a violation of Section 2 is no longer a fortiori a violation of either amendment. Thus, Section 2 can be justified only under Congress' power to enact reasonably prophylactic legislation to deter constitutional harm. Congress' prophylactic enforcement authority is remedial, rather than substantive, and there must be a congruence and proportionality between the injury to be prevented or remedied and the means adopted to that end. Congress-chosen means, moreover, must consist with the letter and spirit of the Constitution. Here, as with everything else in our vote dilution jurisprudence, the task of sound analysis is encumbered by the lack of clear principles defining Section 2 liability in districting. It is awkward to examine the congruence and proportionality of a statutory rule whose very meaning exists in a perpetual state of uncertainty. The majority makes clear, however, that the primary factual predicate of a vote dilution claim is block voting along racial lines that results in majority-preferred candidates defeating minority-preferred ones. And, as I have shown, the remedial logic with which the district court's construction of Section 2 addresses that wrong rests on a proportional control benchmark limited only by feasibility. Thus, the relevant statutory rule may be approximately stated as follows. If voting is racially polarized in a jurisdiction, and if there exists any more or less reasonably configured districting plan that would enable the minority group to constitute a majority in a number of districts roughly proportional to its share of the population, then the jurisdiction must ensure that its districting plan includes that number of majority-minority districts or something quite close. Thus construed and applied, Section 2 is not congruent and proportional to any provisions of the Reconstruction Amendments. To determine the congruence and proportionality of a measure, we must begin by identifying with some precision the scope of the constitutional right at issue. The Reconstruction Amendments forbid, so far as civil and political rights are concerned, discrimination against any citizen because of his race, ensuring that all citizens are equal before the law. They dictate that the government must treat citizens as individuals, not as simply components of a racial, religious, sexual, or national class. These principles are why the Constitution presumptively forbids race-predominant districting, even for remedial purposes. These same principles foreclose a construction of the amendments that would entitle members of racial minorities, qua-racial minorities, to have their preferred candidates win elections. Nor do the amendments limit the rights of members of a racial majority to support their preferred candidates, regardless of whether minorities prefer different candidates, and of whether the majority, by virtue of its numerical superiority, regularly prevails. Nor, finally, do the amendments establish a norm of proportional control of elected offices on the basis of race. And these notions are not merely foreign to the amendments. Rather, they are radically inconsistent with the amendment's command that government treats citizens as individuals, and their goal of a political system in which race no longer matters. Those notions are, however, the values at the heart of Section 2 as construed by the district court and the majority. As applied here, the statute effectively considers it a legal wrong by the state if white Alabamians vote for candidates from one political party at high enough rates, provided that black Alabamians vote for candidates from the other party at a still higher rate. And the statute remedies that wrong by requiring the state to engage in race-based redistricting in the direction of proportional control. I am not certain that Congress enforcement power could ever justify a statute so at odds with the letter and spirit of the Constitution. If it could, it must be because Congress identified a history and pattern of actual constitutional violations that, for some reason, required extraordinary prophylactic remedies. Verk? The legislative record of the 1982 amendments is devoid of any showing that might justify Section 2's blunt approximation of a racial register for allocating representation on the basis of race. To be sure, Senate Judiciary Committee report that accompanied the 1982 amendment to the Voting Rights Act listed many examples of what the committee took to be unconstitutional vote dilution. But the report also showed the committee's fundamental lack of concern with whether those examples reflected the intentional discrimination required to raise a constitutional issue. The committee's principal reason for rejecting discriminatory purpose was simply that it preferred an alternative legal standard. It thought Mobil's intent test was the wrong question, and that courts should instead ask whether a state's election laws offered minorities a fair opportunity to participate in the political process. As applied here, the amended Section 2 thus falls on the wrong side of the line between measures that remedy or prevent unconstitutional actions, and measures that make a substantive change in the governing law. It replaces the constitutional right against intentionally discriminatory districting with an amorphous race-based right to a fair distribution of political power, a right that cannot be implemented without requiring the very evils the Constitution forbids. If that alone were not fatal, Section 2's reach and scope further belie any congruence and proportionality between its districting-related commands, on the one hand, and actionable constitutional wrongs on the other. Its sweeping coverage ensures its intrusion at every level of government and in every electoral system. It has no termination date or termination mechanism. Thus, the amended Section 2 is not spatially or temporally limited to those cases in which constitutional violations are most likely. Nor does the statute limit its reach to attack a particular type of electoral mechanism with a long history, as a notorious means to deny and abridge voting rights on racial grounds. In view of this indiscriminate scope, it simply cannot be said that many of the districting plans affected by the congressional enactment have a significant likelihood of being unconstitutional. Of course, under the logically unbounded totality of circumstances inquiry, a court applying Section 2 can always embroider its vote dilution determination with findings about past or present unconstitutional discrimination. But this possibility does nothing to heal either the fundamental contradictions between Section 2 and the Constitution, or its extreme overbreadth relative to actual constitutional wrongs. A generalized assertion of past discrimination cannot justify race-based redistricting, because it provides no guidance for a legislative body to determine the precise scope of the injury it seeks to remedy. To justify a statute tending toward the proportional allocation of political power by race throughout the nation, it cannot be enough that a court can recite some indefinite quantum of discrimination in the relevant jurisdiction. If it were, courts could uphold race-based remedies that are ageless in their reach into the past, and timeless in their ability to affect the future. That logic would effectively assure that race will always be relevant in redistricting, and that the ultimate goal of eliminating entirely from governmental decision-making such irrelevant factors as a human being's race will never be achieved. For an example of these baleful results, we need look no further than the congressional districts at issue here. In 1992, Alabama and a group of Section 2 plaintiffs, whom a federal court chose to regard as the representatives of all African American citizens of the state of Alabama, stipulated that the state's black population was sufficiently compact and contiguous to comprise a single-member significant majority, 65% or more, African American congressional district, and that, consequently, such a district should be created. Accepting that stipulation, the court reworked District 7 into an irregularly shaped supermajority black district, one that scooped up populous clusters of black voters in the disparate urban centers of Birmingham and Montgomery to connect them across a swath of largely majority black rural areas, without even deciding whether the creation of a majority African American district was mandated by either Section 2 or the Constitution. It did not occur to the court that the Constitution might forbid such an extreme racial gerrymander, as it quite obviously did. But, once District 7 had come into being as a racial gerrymander thought necessary to satisfy Section 2, it became an all but immovable fixture of Alabama's districting scheme. Now, 30 years later, the plaintiffs here demand that Alabama carve up not 2 but 3 of its main urban centers on the basis of race, and now, it configure those urban centers black neighborhoods with the outlying majority black rural areas, so that black voters can control not 1 but 2 of the state's 7 districts. The federal judiciary now upholds their demand, overriding the state's undoubted interest in preserving the core of its existing districts, its plainly reasonable desire to maintain the Gulf Coast region as a cohesive political unit, and its persuasive arguments that a race-neutral districting process would not produce anything like the districts the plaintiffs seek. Our reasons for doing so boil down to these: that the plaintiffs' proposed districts are more or less within the vast universe of reasonable districting outcomes, that Alabama's white voters do not support the black minority's preferred candidates, that Alabama's racial climate, taken as a rarefied whole, crosses some indefinable line justifying our interference, and, last but certainly not least, that Black Alabamians are about 2/7 of the state's overall population. By applying Section 2 in this way to claims of this kind, we encourage a conception of politics as a struggle for power between competing racial factions. We indulge the pernicious tendency of assigning Americans to creditor and debtor races, even to the point of redistributing political power on that basis. We ensure that the race-based redistricting we impose on Alabama now will bear divisive consequences long into the future. Just as the initial creation of District 7 segregated Jefferson County for decades and minted the template for crafting black political homelands in Alabama, we place states in the impossible position of having to weigh just how much racial sorting is necessary to avoid the competing hazards of violating Section 2 and violating the Constitution. We have even put ourselves in the ridiculous position of assuming that compliance with a statute can excuse disobedience to the Constitution. Worst of all, by making it clear that there are political dividends to be gained in the discovery of new ways to sort voters along racial lines, we prolong immeasurably the day when the sordid business of divvying us up by race is no more. To the extent Section 2 requires any of this, it is unconstitutional. The majority deflects this conclusion by appealing to two of our older Voting Rights Act cases that did not address Section 2 at all and, indeed, predate Congress adoption of the results test. That maneuver is untenable. One case upheld the pre-clearance requirements, original coverage formula, and other related provisions aimed at a small number of states and political subdivisions where systematic resistance to the 15th Amendment had long been flagrant. The other case upheld the extension of the pre-clearance provisions for another 7 years. The majority's reliance on these cases to validate a statutory rule not there at issue could make sense only if we assess the congruence and proportionality of the Voting Rights Act's rules wholesale, without considering their individual features, or if those cases meant that Congress has plenary power to enact whatever rules it chooses to characterize as combating discriminatory effects. Neither proposition makes any conceptual sense or is consistent with our cases. In fact, those cases confirm the very limits on Congress enforcement powers that are fatal to the district court's construction of Section 2. For example, one case explained the remedial rationale for its approval of the pre-clearance extension. Congress could rationally have concluded that, because electoral changes by jurisdictions with a demonstrable history of intentional racial discrimination in voting create the risk of purposeful discrimination, it was proper to prohibit changes that have a discriminatory impact. The next section of the case then separately examined and upheld the reasonableness of the extension's time period. Thus, the case stands for precisely the propositions for which another case cited it. Congress may adopt preventive measures when there is reason to believe that many of the laws affected by the congressional enactment have a significant likelihood of being unconstitutional, particularly when it employs termination dates, geographic restrictions, or egregious predicates that tend to ensure Congress means are proportionate to ends legitimate. Again, however, the amended Section 2 lacks any such salutary limiting principles. It is unbounded in time, place, and subject matter, and its districting-related commands have no nexus to any likely constitutional wrongs. In short, as construed by the District Court, Section 2 does not remedy or deter unconstitutional discrimination in districting in any way, shape, or form. On the contrary, it requires it, hijacking the districting process to pursue a goal that has no legitimate claim under our constitutional system: the proportional allocation of political power on the basis of race. Such a statute cannot be considered remedial. Preventive legislation, and the race-based redistricting it would command cannot be upheld under the Constitution. These cases are not close. The plaintiffs did not prove that Alabama's districting plan imposes or applies any voting qualification or prerequisite to voting or standard, practice, or procedure that affects a denial or abridgment of their right to vote on account of race or color. Nor did they prove that Alabama's congressional districts are not equally open to participation by black Alabamians. The plaintiffs did not even prove that it is possible to achieve 2 majority black districts without resorting to a racial gerrymander. The most that they can be said to have shown is that sophisticated mapmakers can proportionally allocate Alabama's congressional districts based on race in a way that exceeds the federal judiciary's ability to recognize as a racial gerrymander with the naked eye. The district court held that this showing, plus racially polarized voting and its gestalt view of Alabama's racial climate, was enough to require the state to redraw its districting plan on the basis of race. If that is the benchmark for vote dilution under Section 2, then Section 2 is nothing more than a racial entitlement to roughly proportional control of elective offices, limited only by feasibility, wherever different racial groups consistently prefer different candidates. If that is what Section 2 means, the court should hold that it is unconstitutional. If that is not what it means, but Section 2 applies to districting, then the court should hold that vote dilution challenges require a race-neutral benchmark that bears no resemblance to unconstitutional racial registers. On the other hand, if the court believes that finding a race-neutral benchmark is as impossible as much of its rhetoric suggests, it should hold that Section 2 cannot be applied to single-member districting plans for want of an objective and workable standard for choosing a reasonable benchmark. Better yet, it could adopt the correct interpretation of Section 2 and hold that a single-member districting plan is not a voting qualification, a prerequisite to voting, or a standard, practice, or procedure, as the Act uses those terms. One way or another, the district court should be reversed. The majority goes to great lengths to decline all of these options, and in doing so, to fossilize all of the worst aspects of our long deplorable vote dilution jurisprudence. The majority recites Gingles' shop-worn phrases as if their meaning were self-evident, and as if it were not common knowledge that they have spawned intractable difficulties of definition and application. It goes out of its way to reaffirm Section 2's applicability to single-member districting plans, both as a purported original matter and on highly exaggerated stare decisis grounds. It virtually ignores Alabama's primary argument, that whatever the benchmark is, it must be race-neutral, choosing, instead, to quixotically joust with an imaginary adversary. In the process, it uses special pleading to close the door on the hope cherished by some thoughtful observers that computational redistricting methods might offer a principled, race-neutral way out of the thicket Gingles carried us into. Finally, it dismisses grave constitutional questions with an insupportably broad holding based on demonstrably inapposite cases. I find it difficult to understand these maneuvers except as proceeding from a perception that what the district court did here is essentially no different from what many courts have done for decades under this court's superintendence, joined with a sentiment that it would be unthinkable to disturb that approach to the Voting Rights Act in any way. I share the perception, but I cannot understand the sentiment. It is true that, under our direction, federal courts have been engaged in methodically carving the country into racially designated electoral districts for decades now. But that fact should inspire us to repentance, not resignation. I am even more convinced of the opinion that I formed 29 years ago. In my view, our current practice should not continue. Not for another term, not until the next case, not for another day. The disastrous implications of the policies we have adopted under the Act are too grave, the dissembling in our approach to the Act too damaging to the credibility of the federal judiciary. The inherent tension, indeed, I would call it an irreconcilable conflict, between the standards we have adopted for evaluating vote dilution claims and the text of the Voting Rights Act would itself be sufficient in my view to warrant overruling the interpretation of Section 2 set out in Gingles. When that obvious conflict is combined with the destructive effects our expansive reading of the Act has had in involving the federal judiciary in the project of dividing the nation into racially segregated electoral districts, I can see no reasonable alternative to abandoning our current unfortunate understanding of the Act. I respectfully dissent. Justice Alito, with whom Justice Gorsuch joins, dissenting. Based on a flawed understanding of the framework adopted in Thornburg v. Gingles, the court now holds that the congressional districting map adopted by the Alabama legislature violates Section 2 of the Voting Rights Act. Like the court, I am happy to apply Gingles in these cases, but I would interpret that precedent in a way that heeds what Section 2 actually says, and I would take constitutional requirements into account. When the Gingles framework is viewed in this way, it is apparent that the decisions below must be vacated. Gingles marked the court's first encounter with the amended version of Section 2 that Congress enacted in 1982, and the court's opinion set out an elaborate framework that has since been used to analyze a variety of Section 2 claims. Under that framework, a plaintiff must satisfy three preconditions. As summarized in more recent opinions, they are as follows. First, the minority group, whose interest the plaintiff represents, must be sufficiently large and geographically compact to constitute a majority in some reasonably configured legislative district. Second, the minority group must be politically cohesive. And third, a district's white majority must vote sufficiently as a bloc to usually defeat the minority's preferred candidate. If a Section 2 plaintiff can satisfy all these preconditions, the court must then decide whether, based on the totality of the circumstances, the plaintiff's right to vote was diluted. And to aid in that inquiry, Gingles approved consideration of a long list of factors set out in the Senate Judiciary Committee's majority report on the 1982 VRA amendments. My fundamental disagreement with the court concerns the first Gingles precondition. In cases like these, where the claim is that Section 2 requires the creation of an additional majority-minority district, the first precondition means that the plaintiff must produce an additional illustrative majority-minority district that is reasonably configured. The court's basic error is that it misunderstands what it means for a district to be reasonably configured. Our cases make it clear that reasonably configured is not a synonym for compact. We have explained that the first precondition also takes into account other traditional districting criteria, like attempting to avoid the splitting of political subdivisions and communities of interest. To its credit, the court recognizes that compactness is not enough, and that a district is not reasonably configured if it flouts other traditional districting criteria. At various points in its opinion, it names quite a few: minimizing the splitting of counties and other political subdivisions, keeping communities of interest together where possible, and avoiding the creation of new districts that require two incumbents to run against each other. In addition, the court acknowledges that a district is not reasonably configured if it does not comport with the Equal Protection Clause's one person, one vote requirement. But the court fails to explain why compliance with traditional districting criteria matters under Section 2, or why the only relevant equal protection principle is the one person, one vote requirement. If the court had attempted to answer these questions, the defect in its understanding of the first Gingles precondition would be unmistakable. To explain this, I begin with what is probably the most frequently mentioned traditional districting criterion, and ask why it should matter under Section 2 whether a proposed majority-minority district is compact. Neither the Voting Rights Act nor the Constitution imposes a compactness requirement. The court notes that we have struck down bizarrely shaped districts, but we did not do that for aesthetic reasons. Compactness in and of itself is not a legal requirement, or even necessarily an aesthetic one. Some may find fancifully shaped districts more pleasing to the eye than boring squares. The same is true of departures from other traditional districting criteria. Again, nothing in the Constitution or the VRA demands compliance with these criteria. If a whimsical state legislature cavalierly disregards county and municipal lines and communities of interest, draws weirdly shaped districts, departs radically from a prior map solely for the purpose of change, and forces many incumbents to run against each other, neither the Constitution nor the VRA would make any of that illegal per se. Bizarrely shaped districts and other marked departures from traditional districting criteria matter, because mapmakers usually heed these criteria, and when it is evident that they have not done so, there is reason to suspect that something untoward, specifically, unconstitutional racial gerrymandering is afoot. Conspicuous violations of traditional districting criteria constitute strong circumstantial evidence of unconstitutionality, and when it is shown that the configuration of a district is attributable predominantly to race, that is more than circumstantial evidence that the district is unlawful. That is direct evidence of illegality because, as we have often held, race may not predominate in the drawing of district lines. Because non-predominance is a long-standing and vital feature of districting law, it must be honored in a Gingles plaintiff's illustrative district. If race predominated in the creation of such a district, the plaintiff has failed to satisfy both our precedent, which requires reasonably configured districts, and the terms of Section 2, which demand equal openness. 2 terms ago, we engaged in a close analysis of the text of Section 2, and explained that its key requirement is that the political processes leading to nomination or election must be equally open to participation by members of a protected class. Equal openness, we stressed, must be our touchstone in interpreting and applying that provision. When the race of one group is the predominant factor in the creation of a district, that district goes beyond making the electoral process equally open to the members of the group in question. It gives the members of that group an advantage that Section 2 does not require, and that the Constitution may forbid. And because the creation of majority-minority districts is something of a zero-sum endeavor, giving an advantage to one minority group may disadvantage others. What all this means is that a Section 2 plaintiff who claims that a districting map violates Section 2, because it fails to include an additional majority-minority district, must show at the outset that such a district can be created without making race the predominant factor in its creation. The plaintiff bears both the burden of production and the burden of persuasion on this issue, but a plaintiff can satisfy the former burden simply by adducing evidence, in any acceptable form, that race did not predominate. A plaintiff need not offer computer-related evidence. Once upon a time, legislative maps were drawn without using a computer, and nothing prevents a Section 2 plaintiff from taking this old-school approach and creating an illustrative district. In that event, the plaintiff can simply call upon the mapmaker to testify about the process he or she used, and the role, if any, that race played in that process. The defendant may seek to refute that testimony in any way that the rules of civil procedure and evidence allow. If, as will often be the case today, a Section 2 plaintiff's mapmaker uses a computer program, the expert can testify about the weight, if any, that the program gives to race. The plaintiff will presumably argue that any role assigned to race was not predominant, and the defendant can contest this by cross-examining the plaintiff's expert, seeking the actual program in discovery, and calling its own expert to testify about the program's treatment of race. After this, the trial court will be in a position to determine whether the program gave race a predominant role. This is an entirely workable scheme. It does not obligate either party to offer computer evidence, and it minimizes the likelihood of a clash between what Section 2 requires and what the Constitution forbids. We have long assumed that Section 2 is consistent with the Constitution. But that cannot mean that every conceivable interpretation of Section 2 is constitutional, and I do not understand the majority's analysis of Alabama's constitutional claim to suggest otherwise. Our cases make it perfectly clear that using race as a predominant factor in drawing legislative districts is unconstitutional, unless the stringent requirements of strict scrutiny can be satisfied. And therefore, if Section 2 can be found to require the adoption of an additional majority-minority district that was created under a process that assigned race a predominant role, Section 2 and the Constitution would be headed for a collision. When the meaning of a reasonably configured district is properly understood, it is apparent that the decisions below must be vacated, and that the cases must be remanded for the application of the proper test. In its analysis of whether the plaintiffs satisfied the first Gingles precondition, the district court gave much attention to some traditional districting criteria, specifically, compactness and avoiding the splitting of political subdivisions and communities of interest, but it failed to consider whether the plaintiffs had shown that their illustrative districts were created without giving race a predominant role. For this reason, the district court's Section 2 analysis was deficient. It is true that the district court addressed the question of race predominance when it discussed and rejected the state's argument that the plaintiffs' maps violated the Equal Protection Clause, but the court's understanding of predominance was deeply flawed. The court began this part of its opinion with this revealing statement. Dr. Duchan and Mr. Cooper, plaintiffs' experts, testified that they prioritized race only for the purpose of determining and to the extent necessary to determine whether it was possible for the Milligan plaintiffs and the Castor plaintiffs to state a Section 2 claim. As soon as they determined the answer to that question, they assigned greater weight to other traditional redistricting criteria. This statement overlooks the obvious point that by prioritizing race at the outset, Dr. Duchan and Mr. Cooper gave race a predominant role. The next step in the district court's analysis was even more troubling. The court wrote, Dr. Duchan's testimony that she considered 2 majority black districts as non-negotiable does not show that race played a predominant role in her districting process. But if achieving a certain objective is non-negotiable, then achieving that objective will necessarily play a predominant role. Suppose that a couple are relocating to the Washington, D.C. metropolitan area, and suppose that one says to the other, I'm flexible about where we live, but it has to be in Maryland. That's non-negotiable. Could anyone say that finding a home in Maryland was not a predominant factor in the couple's search? Or suppose that a person looking for a flight tells a travel agent, it has to be nonstop. That's non-negotiable. Could it be said that the number of stops between the city of origin and the destination was not a predominant factor in the search for a good flight? The obvious answer to both these questions is no, and the same is true about the role of race in the creation of a new district. If it is non-negotiable that the district be majority black, then race is given a predominant role. The district court wrapped up this portion of its opinion with a passage that highlighted its misunderstanding of the first Gingles precondition. The court thought that a Section 2 plaintiff cannot proffer a reasonably configured majority-minority district without first attempting to see if it is possible to create such a district. That is, by first making the identification of such a district non-negotiable. But that is simply not so. A plaintiff's expert can first create maps using only criteria that do not give race a predominant role, and then determine how many contain the desired number of majority-minority districts. One final observation about the district court's opinion is in order. The opinion gives substantial weight to the disparity between the percentage of majority black House districts in the legislature's plan, 14%, and the percentage of black voting age Alabamians, 27%, while the percentage in the plaintiff's plan, 29%, came closer to that 27% mark. Section 2 of the VRA, however, states expressly that no group has a right to representation in numbers equal to their proportion in the population. This provision was a critical component of the compromise that led to the adoption of the 1982 amendments, as the court unanimously agreed 2 terms ago. The district court's reasoning contravened this statutory proviso. The court spends much of its opinion attacking what it takes to be the argument that Alabama has advanced in this litigation. I will not debate whether the court's characterization of that argument is entirely correct, but, as applied to the analysis I have just set out, the court's criticisms miss the mark. The major theme of this part of the court's opinion is that Alabama's argument, in effect, is that Gingles must be overruled. But as I wrote at the beginning of this opinion, I would decide these cases under the Gingles framework. We should recognize, however, that the Gingles framework is not the same thing as a statutory provision, and it is a mistake to regard it as such. In applying that framework today, we should keep in mind subsequent developments in our case law. One important development has been a sharpening of the methodology used in interpreting statutes. Gingles was decided at a time when the court's statutory interpretation decisions sometimes paid less attention to the actual text of the statute than to its legislative history, and Gingles falls into that category. The court quoted Section 2 but then moved briskly to the Senate report. Today, our statutory interpretation decisions focus squarely on the statutory text, and as we held in Brnovich, the key requirement set out in the text of Section 2 is that a state's electoral process must be equally open to members of all racial groups. The Gingles framework should be interpreted in a way that gives effect to this standard. Another development that we should not ignore concerns our case law on racial predominance. Post-Gingles decisions made it clear that it is unconstitutional to use race as a predominant factor in legislative districting. When statutory language is susceptible of multiple interpretations, a court may shun an interpretation that raises serious constitutional doubts, and instead may adopt an alternative that avoids those problems. This same principle logically applies with even greater force when we interpret language in one of our prior opinions. It therefore goes without question that we should apply the Gingles framework in a way that does not set up a confrontation between Section 2 and the Constitution, and understanding the first Gingles precondition in the way I have outlined achieves that result. The court's subsidiary criticisms of Alabama's arguments are likewise inapplicable to my analysis, but I would require only what our cases already demand, that all legislative districts be produced without giving race a predominant role. The court maintains that Alabama's benchmark scheme would be unworkable because of the huge number of different race-neutral maps that could be drawn. As the court notes, there are apparently numerous competing metrics on the issue of compactness alone, and each race-neutral computer program may assign different values to each traditional districting criterion. My analysis does not create such problems. If a Section 2 plaintiff chooses to use a computer program to create an illustrative district, the court need ask only whether that program assigned race a predominant role. The court argues that Alabama's focus on race-neutral maps cannot be squared with a totality of the circumstances test because Alabama suggests there is only one circumstance that matters: how the state's map stacks up relative to the benchmark maps. My analysis, however, simply follows the Gingles framework, under which a court must first determine whether a Section 2 plaintiff has satisfied three preconditions before moving on to consider the remainder of relevant circumstances. As noted, I would vacate and remand for the district court to apply the correct understanding of Gingles in the first instance. Such a remand would require the district court to determine whether the plaintiffs have shown that their illustrative maps did not give race a predominant role, and I will therefore comment briefly on my understanding of the relevant evidence in the record as it now stands. In my view, there is strong evidence that race played a predominant role in the production of the plaintiff's illustrative maps, and that it is most unlikely that a map with more than one majority black district could be created without giving race such a role. An expert hired by the Milligan plaintiffs, Dr. Kosuke Imai, used a computer algorithm to create 30,000 potential maps, none of which contained two majority black districts. In fact, in 20,000 of those simulations, Dr. Imai intentionally created one majority-minority district, and yet even with one majority-minority district guaranteed as a baseline, none of those 20,000 attempts produced a second one. Similarly, Dr. Moon Duchin, another expert hired by the Milligan plaintiffs, opined that it is hard to draw two majority black districts by accident. Dr. Duchin also referred to a study where she generated 2 million maps of potential district configurations in Alabama, none of which contained a second majority-minority district. And the first team of trained mapmakers that plaintiff Milligan consulted was literally unable to draw a two-majority black district map, even when they tried. Milligan concluded at the time that the feat was impossible. The majority quibbles about the strength of this evidence, protesting that Dr. Imai's studies failed to include as controls certain redistricting criteria and that Dr. Duchin's 2 million map study was based on 2010 census data. But this is unconvincing for several reasons. It is plaintiffs' burden to produce evidence and satisfy the Gingles preconditions. So if their experts' maps were deficient, that is no strike against Alabama. And the racial demographics of the state changed little between 2010 and 2020, which is presumably why Dr. Duchin herself raised the older study in answering questions about her work in this litigation. If it was impossible to draw two such districts in 2010, it surely at least requires a great deal of intentional effort now. The court suggests that little can be inferred from Dr. Duchin's 2 million map study, because 2 million maps are not that many in comparison to the trillion maps that are possible. In making this argument, the court relies entirely on an amicus brief submitted by 3 computational redistricting experts in support of the appellees. These experts' argument concerns a complicated statistical issue, and I think it is unwise for the court to make their argument part of our case law based solely on this brief. By the time this amicus brief was submitted, The appellants had already filed their main brief, and it was too late for any experts with contrary views to submit an amicus brief in support of appellants. Computer simulations are widely used today to make predictions about many important matters, and I would not place stringent limits on their use in VRA litigation without being quite sure of our ground. If the cases were remanded, the parties could take up this issue if they wished and call experts to support their positions on the extent to which the 2 million maps in the study are or can be probative of the full universe of maps. In sum, based on my understanding of the current record, I am doubtful that the plaintiffs could get by the first Gingles precondition, but I would let the district court sort this matter out on remand. Despite the strong evidence that two majority-minority districts cannot be drawn without singular emphasis on race, a plurality nonetheless concludes that race did not predominate in the drawing of the plaintiffs' illustrative maps. Their conclusion, however, rests on a faulty view of what non-predominance means. The plurality's position seems to be that race does not predominate in the creation of a districting map so long as the map does not violate other traditional districting criteria such as compactness, contiguity, equally populated districts, minimizing county splits, etc. But this conclusion is irreconcilable with our cases. In Miller, for instance, we acknowledged that the particular district at issue was not shaped, bizarrely on its face, but we nonetheless held that race predominated because of the legislature's overriding desire to assign black populations in a way that would create an additional majority black district. Later cases drove home the point that conformity with traditional districting principles does not necessarily mean that a district was created without giving race a predominant role. We held that once it was shown that race was the overriding reason for the selection of a particular map, further showing of inconsistency between the enacted plan and traditional redistricting criteria is unnecessary to a finding of racial predominance. We noted that the contrary argument was foreclosed almost as soon as it was raised in this court. Race may still predominate even if traditional districting principles do correlate to some extent with the district's layout. Traditional redistricting principles are numerous and malleable. By deploying those factors in various combinations and permutations, a mapmaker could construct a plethora of potential maps that look consistent with traditional, race-neutral principles. Here, a plurality allows plaintiffs to do precisely what we warned against. The plurality's analysis of predominance contravenes our precedents in another way. What? Have been sensitive to the gravity of trapping states between the competing hazards of liability imposed by the Constitution and the VRA. The VRA's demand that states not unintentionally dilute the votes of particular groups must be reconciled with the Constitution's demand that states generally avoid intentional augmentation of the political power of any one racial group, and thus the diminution of the power of other groups. The plurality's predominance analysis shreds that prudential concern. If a private plaintiff can demonstrate liability based on the production of a map that the state has every reason to believe it could not constitutionally draw, we have left state legislatures too little breathing room and virtually guaranteed that they will be on the losing end of a federal court's judgment. The court's treatment of Gingles is inconsistent with the text of Section 2, our precedents on racial predominance, and the fundamental principle that states are almost always prohibited from basing decisions on race. Today's decision unnecessarily sets the VRA on a perilous and unfortunate path. I respectfully dissent. Thanks for listening. This podcast is not affiliated with the United States Supreme Court or its staff in any way. The summary of this opinion given in the introduction was taken from the summary provided at oyez.org. Any mistakes in the opinion you just heard should be attributed to this podcast. If you would like to support my efforts to make Supreme Court opinions available to the public, please subscribe. Thank you.